indulgence in mentioning item number 6 of part 2. Lordship, the senior counsel for respondent number 1 is indisposed. So, on his request, if this matter may come up on 23rd July, I have taken the consent of the other party.
Who, Mr. Liantrima is indisposed?
Yes, Lordship.
23rd. You have it in the last week?
Yes, Lordship. He was there.
Your request is 23rd, but we'll post it on 27th. Ms. Ruth Lal Watfeli, Learned Counsel, appearing for respondent number 1, submits that she is led by our senior, Mr. L.H. Liantrima, Learned Senior Counsel. But as he is indisposed, she prays that the matter be adjourned and listed on 23rd of July 2026. So she submits that she has taken the consent of the Learned Counsel for the other side. Considering the prayer that the matter be listed in the weekly hearing list commencing from 27th of July 2026. All right.
Obliged.
May I seek your Lordship indulgence in mentioning part 2, item number 4. Lordship, although yesterday was a fixed date, if the matter can be kindly taken up after 2 weeks.
You're for the?
I'm for the appellant.
I'm for the respondent, Lordship.
Any objection?
I'm for the respondent, Lordship.
Any objection?
No objection, Lordship.
You are Ms. Ropari.
Yes, Lordship.
On the request of Ms. Lal Ropari, Learned Counsel for the appellant, not opposed to by the other side, matter stands adjourned to be listed again after 2 weeks.
Deeply obliged.
May I seek your Lordship's indulgence in mentioning item number 5, part 2. Lordship, Senior Counsel Mr. Sizoram Chana cannot appear today due to some personal difficulties, and prior consent have been obtained from the Respondents' Counsel. So, Lordship.
You have circulated the adjournment request.
Oh, yes, you have submitted.
Correct.
Yes, my lord.
But then you are to get the signature also.
Oh,
On one side, you'll give your signature, and the other side, whether accepted or not,
okay.
they
We'll
have
do
to
it
give a
next-
signature.
Okay, next time we'll do Lordship.
Next time you
Apologies.
can do that. And one more thing,
Okay.
there is a new format.
Oh, okay.
This is the old format.
We are.
Because I had insisted in the principal seat that this format is not
Okay.
workable, because
Okay.
we don't know who has mentioned, who has agreed to. The new format contains that. So
Okay,
there's a
my
column
lord.
for that.
Okay. We'll submit it.
When
next
do you
time.
want it?
After a week.
Okay, after a week. But why do you want adjournment, Mr.
Sizoram Chana, he's having some personal difficulty and cannot appear today.
We'll post this in the week commencing from 27th.
Yes, Your
Okay.
Lordship. Yes, Your Lordship.
Mr. Sizoram Channel, Learned Senior Counsel, appearing for the petitioner, is said to have some personal difficulty to appear before the court today, and therefore an adjournment has been prayed on his behalf by Miss
R.K. Larin Sangi.
R.K. Lalrin Sangi. Stop the Learned Counsel submits that she has circulated the adjournment request, and the other side has consented to the same. In view of above, the matter stands adjourned to be listed again in the weekly hearing list commencing from 27th of July 2026.
Much obliged.
May I seek your Lordship indulgence in mentioning item number 19, part 2. With the consent of both the parties, if the matter may be taken up after 2 weeks.
19.
Yes, my lord.
FAO,
Yes, my lord.
you are for the
Appellant.
good name?
Lalming Liani.
Okay, on the request of Ms. Lalming Liani, Learned Counsel for the appellant, and not objected to by the other side, matter stands adjourned. Will be listed again in the weekly hearing list commencing from 27th of July 2026. Yes.
Oblige.
for motion, list item number 1.
Yes, Mr. Roku.
May I please, Your Lordship, this instant petition is filed by the President, Chakma Autonomous District Council, Employee Association, for and on behalf of 942 petitioners. They are all regular employee of the Chakma Autonomous District Council. District Council was failed to make payment of the employee for the last 4.5 months, Lordship. The petitioner have submitted several representations even to the governor, but till that no result. Hence, the petitioner are bound to approach this honorable court for justice, Lordship. The similar case has been decided in the Garo Hills Autonomous District Council versus State of Meghalaya, Lordship. In this case, 8 months' salary was not paid to them, and it was during the pendency of the case, Lordship, agreement was made that payment should be made in 2 installments.
Now, why do you say association? They have come individually.
No, Lordship, this president, Lordship, through their president, Annexure 2, Lordship, is the certificate of registration of the employee association, Lordship.
Annexure?
Annexure 2.
Okay. But you see the cost title, you have included all the names.
Yes, we have instruction from the registry to include all the petitioner name, Lordship.
So who is the president?
The president is Nuton Chakma.
I see.
There is a authorization, Lordship, the page.
Okay. The petitioners are working in different capacities.
Yes, different capacity. There are
Like?
20 department, Lordship. Out of 20 departments, there are LDC, UDC, driver, peons, and different category. Teachers, primary teacher education, and then middle school teachers associations, middle school teachers, Lordship. They are posted in different places within the Chakma Autonomous District Council, Lordship. And they were not paid their salary with effect from 16 November to March 2026, Lordship. 16 November 2025 to March 2026. In fact, Lordship, they were paid in the middle, that is first quarter, that is from April to June, they were paid. It was because mainly because that the district council was under the direct control of the governor for the last 1 year, Lordship. So many officials proceedings were not properly functioning. That is why this payment was not made, Lordship.
So it's about 4 months.
4.5 months, Lordship.
4.5 months.
4.5 months.
Now they're getting.
They have get only this new financial year, 2026-27, that is April to June they have get.
Well,
The
that's
remaining,
That's what?
Yes.
This particular period they did not get.
They did not
But
get.
as of now, they're getting it.
Yes, as of now they're getting.
So this is a claim for area.
Yes.
Have you filed any representation?
We have filed several representation, Lordship. That is page number 257, Lordship, that is
257.
yes, Lordship.
So this is a list. Abstract of salary requirement. This is not representation.
Maybe, Lordship, some pagination is
Okay, tell me what is the annexure number?
Yes, I'll tell you, Lordship.
Pen down strike and all that, or what?
Yes, there was a pen down strike, Lordship.
This
and-
is Annexure 32. This is addressed to the Deputy Commissioner.
Yes, Lordship, there is a first representation was filed before the Governor, Lordship, that is 255, Lordship, in my page.
Okay, please write. Heard Mr. A.K. Rokun, learned counsel for the petitioners, who submits that the petitioners numbering 942 having common grievance against the respondents concerned have jointly filed the instant writ petition. So he submits that the petitioners, in fact, are members of the Chakma District Council Employees Association, which is a registered association under the Societies Registration Act. And the petitioner number 1 is the president.
Yes, President.
So he submits that the petitioners are working in various capacities under the Chakma Autonomous District Council, bracket CADC, and have been getting their regular pay from time to time. However, the petitioners were not given any pay or salary for the period between 16/11/2025 to March 2026, which is for 4.5 months.
4.5 months, Lordship.
Aggrieved, the petitioners had approached the various authorities, including the
The caretaker, Deputy Commissioner Longklai, and the
caretaker of the district council, caretaker of the CADC, that is the deputy commissioner. What deputy commissioner of what?
Longklai District.
Longklai district.
Yes, Longklai District.
And also the governor of the state. However, since their grievance has not been redressed, they are before this court. The learned counsel submits that the petitioners otherwise have been paid their salary for the first quarter, that is April to June 2026-27. But their area salaries remains unpaid. Next para, in view of above, you should notice a motion returnable by 4 weeks. Ms. Louis Learned Government Advocate accepts notice on behalf of the respondent numbers 1 to 4.
Yes, Your Lordship.
Requisite copies of the writ petition be furnished to her within 2 days. For petitioners to take steps for service of notice upon the respondent number 5 by speed post within 2 days, within 3 days. List again after 4 weeks.
Obliged, Lordship.
Pendency of the writ petition will not be a bar for the respondents to mitigate the grievance of the petitioners.
Item number 2.
May it please your lordship. This matter pertains to the non-appointment of a fresh arbitrator under the Railways Act, my lord. The petitioners are owners of lands, and their lands have been acquired for the purpose of new railway line, Pairabi to Sairang, by the ward number 3 of 2019. And the petitioner had earlier filed arbitration case number 7 of 2023 before the respondent number 4, and the same was contested by the railway authorities. And after hearing the parties, the respondent number 4, who is the arbitrator, had disposed of the arbitration case by common order dated 8/3/2024, and that the amount of compensation fixed by the respondent number 3, who is the deputy commissioner, needs no revision. Thereafter, the petitioner, being aggrieved, had challenged the order dated 8/3/2024 by filing an application under Section 34 of the Arbitration and Conciliation Act, and the said application was registered as arbitration application number 8 of 2024 before the Court of Additional District and Sessions Judge 2. And by judgment and order dated 24/4/2025, the matter was remanded back to the arbitrator number 4 for proceeding afresh and re-adjudication of the matter within a period of 6 months. In spite of the judgment and order dated 24/4/2025 having been passed, the respondent number 4 had not taken any action, and he has written a letter dated 13/5/2025 to the General Manager for Construction, Northeast Frontier Railway, to appoint a fresh arbitrator in his place. And since then, the matter has been kept in abeyance, my lord.
What is this order at page 114?
Page 114, my lord, this is a similarly situated person, and this case can be disposed of as a covert matter, my lord, if your lordship permits. In this case also, the petitioner herein has the same grievance as the present petitioners, and this honorable court, by this order dated 29/1/2026, had directed the railway authorities to appoint a fresh arbitrator.
This pertains to a different area.
Different land passes, my lord. Same award, different land passes.
No, the direction of this court was to appoint an arbitrator.
Arbitrator.
Correct. So,
Yes, my lord.
has it been appointed? Has any arbitrator been
My
appointed?
lord, they have appointed an arbitrator, but they have appointed in terms of case-wise only.
Case-wise?
Yes, my lord.
Yes.
My lord, in the earlier 5 writ petition, they already appointed Sri Vinod P. Kafle, IAS, and the same has been sent to the Chief Secretary, Government of Mizoram, for giving to consent to it.
That was appointment for a specific case.
My lord, if I may permit it to submit my instruction letter.
You're talking about this WPC 107, Ms. Zainab Sangpui?
105 2025, 106 2025, 107 2025, 133 2025, and 15 of 2026.
For all those cases, some name has been proposed
Yes, my lord.
and it has been sent for the approval of the
Yes,
CS.
my lord.
But what about this present case?
My lord,
So appointment is done only on specific cases, case to case,
in persons to
not
the
generally.
in persons to the court order, my lord.
Correct. Court order was there. This order is at page 114. The trial court had remanded back for fresh adjudication. One zero five, 107.
It's okay, so in some we can get down to
Difficult to read your document you're giving me,
My lord.
it's hardly legible. Who is required to appoint the arbitrator?
The railways, my lord.
So you take instructions in this case,
The respondent number 1 and 2.
Mr. Zaram Zakwi,
Yes, my lord.
since they have already forwarded one name in respect of those bunch of cases, why not include this present case also?
Yes, my lord.
Then problem will be solved. Please write. Heard Mr. Zoram Chana, learned counsel for the petitioners who submits that the petitioners are before this court with a grievance that the respondent numbers 1 and 2 have failed to appoint a substitute arbitrator under the provisions of section 20 dash capital F bracket 6 of the Railways Act, 1989, read with Rule 3 of the Land Acquisition, open bracket, Special Railway Projects, close bracket, Rules, 2016. After the withdrawal of the previous arbitrator, bracket, respondent number 4. Stop, he submits that a similar issue had cropped up in WPC number 107 of 2025, and this court, white order dated 29/1/2026, had disposed of the said writ petition by directing the respondent authorities concerned to appoint fresh arbitrator in accordance with the law. Next, para, at this stage, Ms. Zaram Sangpui, learned CGC, has produced the instructions received by her in respect of WPC number 107 of 2025 and similar other cases. So she submits that the respondent number 1 and 2 has proposed the name of has appointed one Shri Vinod P. Kavi, Kavie, IAS, as an arbitrator for the 5 writ petitions, which includes WPC number 107 of 2025. And the same has been forwarded to the Chief Secretary, Government of Mizoram, for his consent on 18/5/2026. Stop, to substantiate her submission, she has produced a copy of the said communication dated 18/5/2026. Stop. Next para, having regard to the above position, learned CGC shall obtain instructions as to whether the instant writ petition, that is WPC number 87 of 2026, can also be included for consideration by the appointed arbitrator or as to whether a separate arbitrator will have to be appointed. Stop to enable or obtain such instructions. How much time should you require?
1 week.
A week's time is granted. I'm not issuing notice also.
Yes, my lord.
List again next Thursday on 23rd.
Obliged, my lord.
One more line, a copy of the communication dated 18/5/2026 produced by Ms. Zairam Shankwi, knowledge CGC, it shall be retained in the record and marked as X for identification.
From orders list, item number 10.
Your Lordship, may it please Your Lordship, by virtue of the orders 10/6/2026, the previous council was given an instruction to withdraw his power. And the same has been done early this morning, which is not in record. And I will be the new council representing the appellant.
Who's the previous counsel?
The lead counsel is Mr. Jonathan Dalrindlo.
Previous counsel.
Yes, my lord.
So whether application is submitted or not?
Along with my power of appearance, it is submitted, which is still in the registry.
No, your power is one thing, but
Yes.
what about the previous counsel?
The previous council has prepared his application before the Assistant Registrar Judicial.
When?
Along with my power, I have filed it, Lordship.
It should be here.
Yes.
Why should it lie with the assistant registrar?
Yeah.
It should be in this file, the application for withdrawal. The last order says, accordingly, the learned counsel is directed to file proper application along with intimation to the appellant.
My lord, since it is only filed this morning, it is not in the file yet.
You have filed your power, isn't it?
Yes, along with his application, and in which also record his intimation.
What is your
to
good
the-
name?
Kevanlal Naipuya.
K. Vanlal
Naipuya.
Naipuya.
Yes, Lordship.
Give in the writing in a piece of paper.
Lordship.
Mr. K. Vanlal Naipuya, learned counsel, submits that he is the newly engaged counsel in the matter. And the previous counsel, the previous engaged counsel has also given his NOC. Stop, he submits that he has submitted his Vakalatnama along with the said NOC for the registry. When? Yesterday?
This morning, Lordship.
This morning.
Yes.
Stop, since the same is not yet on the record, registry shall verify and connect the same to the record and list the matter again on Monday. Give the date, huh? Monday.
20th of July. Item number 11.
My lord, in this case, Ms. London Louis has to file WO to the IA filed by the respondent in the main appeal.
IA for what?
IA for
For, my lord, I have for releasing 15% of compensation which was deposited to the first track court, Colosseum. My lord.
You are required to file application. Oh, you file application.
Yes, my lord.
And government advocate was required to file objection.
yes, ma'am.
It has not been filed.
It has not been filed, I believe.
Where's she? Lalun Lui. Just inform her. We'll pass it over for the time being.
Item number 12.
May it please your lordship.
Now, before that, Ms. Vanessa, you've got the case diary?
Yes,
Okay. Yes, what is your application about?
My lords, this bail application is filed under section 482 of the BNSS, my lords. And the brief facts of the case is that, my lords, Inspector Jason of Excise and Narcotics received a specific information that Mr. Thang Tin Kapa was transporting a contraband article. And then he was located at Aizawl, and during interrogation, he disclosed that the contraband article was sent and transported in sumo Huang Leng to Aizawl service. And then the sumo was folded at Zemabok, and 13.119 kgs of methamphetamine was seized. And then, as per the statement of the main accused, Mr. Thang Tin Kapa, and the present petitioner was located at
The contraband substance was seized from whom?
from the sumo, which was sent by Mr. Thang Tin Kapa. As per as per his disclosure statement, it was seized from sumo.
From the vehicle?
Yes, from the vehicle, sumo service.
Okay. And the applicant was also a passenger?
No, my lords. He was he's a seaman mystery living in currently living in Sairang. And then, as per the statement of Mr. Thang Tin Kapa, the contraband article was to be delivered to him, to the present petitioner.
I see. And Thang Tin Kapa has already been arrested?
Yes, my lords.
Where was he, Thang Tin Kapa?
He was located and halted at Aizawl. He was driving his taxi, and then he was taken to excise office. And then, as per his disclosure statement, the contraband article was seized from sumo.
Okay. So, what about the occupants of the sumo? Anybody arrested?
No, no one is arrested.
Simply the contraband substance was traveling alone in the vehicle like that?
I think maybe, my lord. So the driver was also not arrested because they believed that he was not aware of the contraband article. He was
Driver
carrying
was not
transport.
aware?
Yes, my lord.
Passenger was not aware? Nobody was aware?
Nobody was aware.
But the contraband was seized?
Yes, my lord.
Then how did this Thang Tin Kapa come in picture?
As per their specific information, my lord, the contraband article was transported by Mr. Thang Tin Kapa. And then he was located. And then, as per his disclosure statement, he sent the contraband article was through sumo MZ01N for 674. So, and then, as per his disclosure statement, the contraband article was seized.
See, how is this Thang Tin Kapa implicated in this matter, since he was not a passenger of the sumo also?
Yes, he was not the passenger.
Then how his
But
name?
as per their specific information, the contraband article was transported by Mr. Thang Tin Kapa, as per the story of the prosecution, my lord.
Okay, then it was to be delivered to the applicant,
To the applicant, my lord.
who is a seaman mystery in Saira.
Yes, my lord.
And
then,
because of that, he was arrested.
yes, my lord. So they were arrested on 6th of March 2026 at 7 p.m.
They means both of them
Yes,
together.
yes, they were arrested at the same time.
Caesar was also done on 6th of March,
Yes, my lord.
5 p.m.
5 p.m.
and 7 p.m.
7.
After 2 hours, they were arrested.
Yes, they both were arrested.
From?
At the Excise and Narcotics Office.
They
They were taken to Excise and Narcotics Office and then arrested at the same time. At
They
the
were
office.
taken from where?
My lords, initially, Mr. Thang Tin Kapa was located at Aizawl. I don't know the exact place, my lords, while he was driving his taxi.
Okay.
And then he was taken to Excise and Narcotics Office. And then they interrogated, and he disclosed that the contraband article was seized. I think he may be taken to Zemabok at the PO where the article was his. And then after that, he was taken to Excise and Narcotics Office. And then as per his statement, the present petitioner was implicated, and the present petitioner was located at Hunterveng, and he was taken again to Excise and Narcotics Office. And then at that place, they both were arrested. Formal arrest was made.
Okay. So arrests happened in the month of March.
Yes.
What is the status now? Charge sheet
Investiga-
filed? Not yet.
No, my lords. Investigation is still going on.
Okay. Have you applied for bail earlier?
No, my lords. This is the present petitioner directly approached this honorable court through this bail application because, my lords, his fundamental rights has been infringed, my lords.
Like what?
47, the grounds was not informed, and Section 48, the family or friends of the accused were not informed, my lords.
Hmm. 47 BNSS. So one is 47.
Yes, my lords. My lords, there is a notice under Section 47, which is at page number 16.
Page number 16.
Yes, my lords. And the English translation is at page 17. No, my lords, as per the format used by the arresting officer, my lords, he has three options. Whether he kept the contraband article in his house, or smuggling, or transport. He has three options. But which one is the allegation against me? I was not informed, my lords. Whether I kept at my house or smuggling, involved in smuggling or transporting the contraband article, my lords.
Where do we get those choices?
So this is the choice of the arresting officer, my lords.
No, you say that there are options.
Yes, the
Where is that choice or option given?
I was, my lords, this is the option as per the format used by the arresting officer, my lords. And my lords, in comparison to the notice given to me, and the co-accused, Mr. Thangtin Kapa, was also given a notice, which is at page number 18. He was informed that he was smuggling. Tick mark was given.
Yes, tick mark is what? Call 2.
Kol konga toltu.
Call 2. In possession. Possessor. You are the possessor of that seized article. This is what it says.
Yes, my lords.
So what is wrong in that?
My lords, pardon?
They have given you the grounds of arrest,
Yes.
saying that this amount of methamphetamine has been recovered, and therefore there's violation of 22C. You are the possessor. Therefore, you have been arrested.
So, my lords, the allegation against me is that, which is founded on page number 10. Page number 10, my lords. This is the FIR. The operative part is at page number 10. The last paragraph. If I may read, my lords. During interrogation, further interrogation, Thang Tinkapa revealed that the consignment was meant to be received by a Y person in Aizawl, whose mobile numbers were so and so and so and so. This is my mobile numbers, my lords. Acting on this information, we contacted the said person and arranged to meet him at company paying Edentar. Due heavy traffic congestion, we could not reach the rendezvous point in time, and therefore instructed the person to approach us before reaching company paying. At around 6 p.m., we finally located the intended receiver, whose name was Samsul Haq. He was brought to our station for questioning. This is the allegation against me, my lords. But I was not informed. I was not informed that in the grounds of notice under section 47 purported to be sent to me. So these facts, basic facts, were not informed to me, my lords.
No, the grounds of arrest itself says that your name, address, time, the contraband substance seized, the weight, and you being the possessor of the seized article,
No, my lords.
and violation of 22C, and that you have a right to engage a lawyer.
My lords, here there are the arresting officer has three options: whether I kept or smuggling or transport, my lords. I was not informed. There is no tick mark given.
Sigma is given here, call to.
No, my lords, that one is the co-accused, my lords.
Oh, okay. Inspector. No. Page 16. This is Samsul Haq.
Page
You are Samsul Haq.
Yes, my lords.
Correct.
But my lords, I was not. The contraband article was not seized from me, my lords.
It was not seized for you.
Yes,
But it
yes.
doesn't have to be like
Yes.
that.
It
Being
was,
in possession does not mean that you have to have it in your hand like that. Carry it everywhere.
So, as per-
Possession means you have control over that thing. You know where it is. You are to receive that amount.
Yes, my lords, at that point of time, I have no control over that contraband article, no conscious possession, and that the allegation against me is that it was to be delivered to me. It was to be delivered to
You
me.
don't
my lords.
deny that also, isn't it?
So-
They gave you a call, you
I
also
deny
met
that
them.
merely because of the co-accused statement, my lords, I was arrested. My lords, with regard to section 48 of the BNSS, intimation, the purported notice which was sent is at page number 22, my lords.
22.
Yes. And English translation is at page 23, my lords. Here, my lords, it was merely mentioned that since the wife would not come to the PO, intimation was given via the above mentioned phone number. It was not sent to me, my lord, to the wife. And here, my lords, it was merely mentioned that the accused was kept in his custody since 6/3/2026. That is the only incorporated in this notice, my lords, purported notice.
So, since the intimation could not be given, I mean, the person intimated could not come, information is given through a phone. You have also acknowledged the same.
The the accused acknowledged the same. And my lords, the reason why he has given by the arresting officer is that he could not come to the PO. PO is the place of occurrence. The PO is Zemabok. So he may request to come to office. So he may give the notice. So he requested her to come to Zemabok, the place of occurrence. That is where the contraband article was seized.
So,
So my lords, the grounds in a perusal of this
where
arrest
is the
intimation,
wife?
she lives in Karimganj.
Karimganj.
Yes, my lords.
So she was contacted over phone in Karimganj.
As per the statement of the arresting officer,
She is not in Aizawl.
she's not in Aizawl, my lords.
Oh.
So my lords, a perusal of the arrest intimation, the grounds of arrest, the basic facts for which the accused was arrested was not informed. What has been incorporated is that he is being kept in custody since 6/3/2026. That's it, my lord.
No, you have shown me this arrest intimation, grounds of arrest. According to you, which provision is violated?
Section 47 and 48 of the BNSS, my lords.
47 says, communicate with full particulars of the offense. It has been given, page 16.
And such other grounds, my lords.
Grounds also is given at page 80.
Page 18 is, my lords, the co-accused.
I'm sorry, it's co-accused.
Page 16.
16, grounds of arrest. Then, reason for arrest. Page 20. Intimation. Under 48, page 22. So all these things have been done. What is wrong?
My lords, as per the arrest intimation section 48, my lords, the grounds were the basic facts for which he was arrested was not informed at all, my lords. The section was also not mentioned.
Yes.
And then the accused wife is living in another state. And then the arresting officer can very well send to speed post by way of post, my lords. But nothing has been done.
You have any decision to cite?
Yes, my lords. Your lordship judgment. Your lordship judgment in bail application number 20 of 2026, my lords. That the relevant.
You could not get a better printout. Should be readable. You see, it's high, so faded.
I think, my lords, my sincere apology that because of maybe my printer, my lords, we have refilled it, the ink, my lords. We just refilled it.
I'll also apologize by rejecting your bail if you give me such kind of paper. Earlier the day, Mr. Zairam Sampu also had given me one piece of paper, which was also very difficult to read. Again, you have repeated the same thing. Please take out a printout. Just take this number. Reference Kaziagla, printout. Read the paragraph which you want to
From para 10, my lords.
Read.
In this connection, we may refer to the decision of the Honorable Apex Court in Bihan Kumar Supra, wherein the Honorable Apex Court has held that the requirement of communication grounds of arrest in writing is not only to the arrested person, but also to his friends, relatives, or such other persons as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22(1) of the Constitution of India meaningful and effective, and failing which, such arrest may be rendered illegal. Further, the Honorable Apex Court in Kasir Reddy, Upender Reddy, Supra, in the given facts and circumstances of that case, held that the grounds of arrest should not only be provided to arrestee, but also his family members and relatives, so that necessary arrangements are made to secure the release of the person arrested at the earliest possible opportunity, so as to make the mandate of Article 22(1) of the Constitution of India meaningful and effective, failing which such arrest may be rendered illegal. The Honorable Apex Court in Prabir Purkavista Supra had taken into consideration the earlier judgment of the same rendered in Hari Krishnan versus State of Maharashtra, reported in 1962, SEC Online SC 117, wherein it was held that communication of grounds of detention to the detainee in writing and in a language which he understands is imperative and essential to provide an opportunity to detainee to making an effective representation against the detention. Reference was also made to the case of Lullabai Jogibai Patel versus Union of India, reported in 1981 to SEC 427, wherein it was held that the grounds of detention must be communicated to the detainee in writing in a language he understands, and if the grounds are only verbally explained, the constitutional mandate of Article 22(5) is infringed. Of course, the two decisions pertains to arresting being made under the preventive law, but however, the ratio would apply to the instant case having regard to the decision rendered by the Honorable Apex Court in Bihan Kumar Supra, the Apex Court in the case of State of Karnataka versus Sri Dasan, etc., criminal appeal number so and so, at paragraph 21.5, held that while Section 50 SCRPC, which is pari materia to Section 48 of the BNSS 2023, is mandatory, the consistent judicial approach has been to adopt a prejudice-oriented test when examining alleged procedural lapse. The Honorable Apex Court therefore held that mere absence of written grounds do not ipso facto render the arrest illegal, unless it results in demonstrable prejudice or denial of a fair opportunity to defend. However, the fact remains that prior to the decision rendered in Sri Dasan, etc. Supra, the Honorable Apex Court in Pankaj Bansal versus Union of India, reported in 2024, 7 SCC 576, Prabir Purkavista Supra and in Bihan Kumar, has statutorily held that the arresting authorities should not only furnish the grounds of arrest in writing to the arrestee, but also to the family members of the arrested person, and the same is a mandatory requirement under sections 47 and 48 of the BNSS. A similar issue came up before the division bench of this court in National Investigating Agency versus Thangminglen Mate, and the division bench held that since the decision rendered in Sri Dasan was in a later point of time after the decision is rendered in Pankaj Bansal Supra and Bihan Kumar Supra, etc. And therefore, having regard to the ratio laid down by the Apex Court in National Insurance Company Limited versus Pranay Sethi, reported in 2017, 16 SCC, page 680, when a situation arises that there are two conflicting decisions, the decisions rendered in an earlier point of time has to be followed. I'll skip para 11, para 12, my lords. The above being the position, I find that the requirement of Section 48 of the BNSS is not met in the process of arrest of the applicant. No materials has been produced before this court that, apart from the arrest intimation given to the applicant, a written arrest intimation was sent to his relative within or outside the state. In fact, in such a situation, if the relatives of the arrested person does not reside within the state or resides in a far-flung district within the state, the arresting authority could very well send the intimation of arrest in writing to the relative concerned by post, and also send a copy of the same to the officer in charge of the police station concerned, where the relative resides for the delivery to the relative. If such procedure was adopted, the case would have been different, as there are no indication that such written communication ground was made to the relatives in the language understood by them. This court is of the view that the applicant will have to be released on bail.
The applicant was of resident of which place in that case?
Karimganj and Moinala.
Winana.
But currently he's living in Sairang. He's a cement mystery.
No, in that case which you just read, the judgment.
Manipur.
So written intimation was required
Yes.
by way of post and all that.
Yes, my lord.
And reference was made to what? Vihan
Vihan Kumar.
Kumar.
Yes.
Any other citation?
No, my lord. That is my humble submission, my lord.
See, so far as 47 is concerned, you have been given, isn't it? Grounds of arrest has been given to you. What is there to complain regarding grounds of arrest?
My lord, my complaint is that, my lord, I was not clearly informed whether I keep the contraband article, or whether I transported it, or whether I involved in smuggling.
Now, whether this methamphetamine is a legal substance, anybody can carry it anywhere they want.
No, my lord.
They cannot,
They cannot.
especially when it is 13.119 grams.
13.1.
So if you are found with that thing, you are caught. You need not be so told that this is not legal, this is illegal. You have carried, we'll catch you.
But let's,
The fact that you are possessing this is illegal, and possession does not mean physical possession. It
Correct,
has to
Manoj.
be. It can be interpreted that you know where the location is. Supposing you kept in the forest, you know where it is. Nobody knows. You know it's kept there in the forest. You only can go and take it out.
my lord.
Still, you will be in possession of that. Although you may not have physical possession, but you know where it is, and anytime you can go and recover it.
Correct, my lord.
Here in the format they have prepared, they say that kol tu, that means you are the possessor of the methamphetamine. So apart from this, there are other choices. You are the, what do you call, dealer, transporter, like that. Recovered from your house, like that. So they have ticked the thing, possessor,
My lord, my main grounds is section 48, arrest intimation, my lord.
arrest intimation.
Yes.
Intimation is again another thing. A written intimation has been written here. Since intimation was given to your wife residing in a different state. So phone number was given by you. They gave a phone call, informed that we have arrested him. You also have given your signature. Yes, phone call is made.
But my
I
lord,
acknowledge.
the grounds was not mentioned. What has been mentioned is that he has been kept in custody since 6/3/2026.
So why
That's-
don't you
that's-
read section 48? Do you have section 48 with you?
No, my lord,
I'll read it for you.
section 48, my lord, if I may read, my lord.
Oh, you have it? Read.
Yes. Yeah. Section 40, obligation of person making arrest to inform about the arrest, etc., to relative or friend. Every police officer or other person making any arrest under this Sanhita shall forthwith give the information regarding such arrest and place where the arrested person is being held to any of his relatives, friends, or such other persons, as may be disclosed or mentioned by the arrested person for the purpose of giving such information, and also to the designated police officer in the district.
So,
My lord, yeah, I have.
do you read anything like reason, grounds?
Yes, my lord. In Vihan Kumar, my lord, it was clearly mentioned that.
No, leave that Vihan Kumar for the time being. In this, for section 48, intimation is given regarding such arrest.
Yes. The
It does not say
information-
intimation should be given, he is arrested for this reason or for that reason or for the grounds or violation of this. So, Specifically, that is not there in section 48.
The information regarding such arrest and such place, the place is informed, my lords. But my lords, it was merely mentioned that it was informed through mobile number. But my lords, there is no proof to show that it was really informed to his wife.
Then why did you put your signature?
Not the accused put his signature, my lords.
When I say you, I mean the accused, not you as a counsel.
Yes, my lords.
Samsul Haq has put his signature,
Yes, my lords.
date, everything.
Correct.
So in his presence only, they gave him a call because you had only provided. Police will not have the number of your wife. You gave the number to the police. They gave a call to your wife and say that you are arrested. That much, you are arrested and you are in their custody. They have not said that you are arrested because of methamphetamine, this, nothing like that. You are arrested and we are keeping him in the custody. And you said yes, gave your signature. So that meets the requirement of 48. Now, if Vihan Kumar says something beyond that, let's see what does it say.
Yes, my lords.
And the judgment which you have just read, it says that it has to be sent by post also,
Yes, my lords.
if you reside in a different state.
Yes, my lords.
There is no such kind of,
Yes, no.
okay.
Nothing has been done, my lords.
That is one aspect.
Yes, my
Of
lords.
course. You are reading paragraph 11 or 12.
Paragraph 10 and 12. Paragraph 11 is the submission made by the learned people.
Where is the decision of the apex court regarding sending the written intimation to the address? If it's outside the state. Have you brought those judgments? Pravir Kumar, Pravir Prakasta and Vihan Kumar.
I have Vihan Kumar, my lords.
Vihan Kumar.
Yes, my lords.
Have you given the list of books?
No, my lords.
Then
If I
how do you plan to argue your case?
if I may be allowed to submit, my lords.
Yes. You have an extra copy?
Yes, my lords.
Okay. That is what? Prabir Prakasta. What is this?
Vihan Kumar, my lords.
Vihan Kumar.
Yes.
What is the relevant para?
It is at page number 17, para 3, the second part of the judgment.
17.
Page 17, yes. Para 3.
Justice Koteshwar's input. No, this is regarding reasons for arrest. I'm talking about section 48, communication. You have anything on section 48?
No, my lords, just Vihan Kumar, my lords.
Okay. Anything more?
No, my lords.
Yes, TP.
Yes, Your Lordship. With regards to section 47 and 48, Your Lordship, the citation which the learned counsel has placed, it's only mandate that it has to be communicated in writing. And in the present case, it is communicated in writing, and there is nowhere to be found that there is a prescribed mode or format. The objection which the counsel has made that the mode in which the grounds of arrest has been produced to him. But in that regard, Your Lordship, there is no mode prescribed. It is just written that it has to be given to him in writing. And in that regard, Your Lordship, I would like to rely on the same citation which the counsel had relied, Vihan Kumar, para number 26.2.
Yes.
The information of the
No,
ground.
just a minute. Vihan,
Yes, Vihan Kumar, 26.2, para number 26.2.
you're reading from what? There's no point two here.
In the conclusion part, Your Lordship, 26, para number 26, and there is a subclause, 26.2.
See, this is a printout from Supreme today.
What
You're
I'm-
reading from
what I'm
something
reading
else.
is, SEC,
SEC.
yes.
Paragraph numbers don't tally. So you have to tell me how does it start?
On here, B, it is in B. Para number 21, subclause B.
No, paragraph does not tally. Your paragraph is different, mine is different.
On
So tell
paragraph
me,
number
how does the
21.
sentence begin?
Therefore, we conclude the conclusion part.
Therefore, we conclude.
Yes, the conclusion part.
Is the last in the last part?
Yes, page number 14.
Again, you're telling me page number, paragraph number. It doesn't make any sense to me.
Actually, this is not my copy, Your Lordship. My copy is the SEC one, and
So that's why I cannot identify from where you're reading. This is the problem. Justice Koteshwar Singh has given his own judgment somewhere in the last part. Is it before that?
it's in para 21, which the council had produced. Para 21.
Oh, therefore we conclude.
Yes, para 21, subclause B. The information of the grounds of arrest must be provided to the arrested person in such a manner that Sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language which he understands. The mode and method of communication must be such that the object of the constitutional safeguard is achieved. So, Your Lordship, it is very clear that the object is to enable him to know that why he is arrested. And in the present case, he is very well aware. And in that regard, his statement, which I have received from the case ID.
The investigation is still going on.
Yes, Your Lordship, investigation is still going on. Charge sheet has not been submitted.
Yes, read what you want to read.
It is in Mizo vernacular.
Read.
Kamhing le ka chen na chu achunga tarlan ang hi ani a Mizoram a hian kumnga vel ka om to a cement work helper na ka thok thi na tu na hian sai ranga omi hotela ka thok ani sai ranga chuan ka thian pa Aslam Uddin in lo a ka khosa ve ani Mizoram a misri na thok thin Salim Uddin nen hian na kan thok dun thina ama hi chu an kwa a pathar kan dia a om to ani nen hian kan in berenga kumsang ni somni panga December vel khan damdoi aizol atanga sai rang rail station thleng lak sak turin min bia a kan in rem siam na angin sing ni loin methamphetamine box thum kalolak sak to ani hemi tum hian ka lo hi pui safain min pe a damdoi lo keng tu mizo ka phona Petty leza ti a ka safe chu a lo tur poisa singa po ka penghal bok ani niruk thlathum sang ni somni paruk lai khan salima chuan methamphetamine dang aron thleng don ti min shil le a ama ang boka lak sak tur le sai rang rail station a akuta peturin min ron shil le a Salimanian hian akhatokin hemini hian kan in bechar chara chanchin po kan in shil reng ani damdoi keng tu chuan tlaida rok vel khan aizol athlen to thu min ron shila company penga in muturin kan in beta ani company peng chu traffic jam wanga an ron thlen theilo awangin a chhak dewa an omna chu ka scooty khal lai chuan ka pan chhota a ma se duty te chuan min lo sheng hala an office lama min shwai ta ani duty te chu excise and narcotic department lam an ni a damdoi keng tu kapu chu an lo man to a damdoi ken po an lo man vek to an lo mang vek to ani ke po damdoi la tu tur ka ni ti chu duty te chuan an sheta ani hemi zandar sari pm chuan thu shetu te mu lain min man ve le ta ani kan case ayo chuan kan mobile phone po min lak sak le ta ani so your lordship it is very clear that at first the co-accused was arrested and from him they trace the present applicant your lordship I would like to rely on the grounds of
You pass me the case diary also.
yes
You mark it, anything has to be seen apart from that. It's all in vernacular. The other judgment,
yes Kasiredi
yes, what is that?
para number 21 that is the same thing your lordship I will go to para number 28 For the purpose of clause 1 of Article 22, it is not necessary for the authorities to furnish full details of the offense. However, the information should be sufficient to enable the arrested person to understand why he has been arrested. The grounds to be communicated to the arrested person should be somewhat similar to the charge framed by the court for the trial of the case. So it is very clear that only the basic facts is necessary. And then, Your Lordship, I will conclude my submission.
What do you say about 48?
48, Your Lordship, in that regard, there is no mentioning that that has to be sent in a post office or something like that. But here in the present case, the accused himself has given the phone number of his wife, and that was also acknowledged by himself. And she was communicated. And the council failed to submit that they had not been called, or the wife has not been called or not. It's just a presumption that he stated that the wife was not intimated. But it is clearly seen that her phone number is also written there, and which was also provided by the accused himself.
Now, why is the investigation taking so long?
Now they were about to file the charge sheet. Your Lordship.
Last entry, where's the last entry? You've given me only February, March 16.
That is the only CD I have received.
It cannot be. See, we are in July now. This is not updated.
They told me that they were about to file the charge sheet.
Maybe. But when we ask for case diary, it doesn't mean that you have to give us only some part of it and the other part will be not given for the reason that they're going to file charge sheet. You are reading from which page?
The statement part.
Statement of the accused.
Yes.
Okay. Anything?
No, my lords.
Okay, heard Mr.
Yes, Vanal
S. Vanal Shriyata, learned counsel for the petitioner, and Ms. Vanisiami, learned additional public prosecutor for the respondents. Stop the petitioner by filing this petition as under section 483 of the BNSS, read with section 37 of the NDNPS Act, as paid for his enlargement on bail. Stop. According to the petitioner, he was arrested on 6/3/2026 at 7 p.m. by the excise personnels in connection with recovery of 13.119 kilograms of suspected methamphetamine kept in 13 bundles in a Tata Maxicab Sumo bearing registration number MZ01 N4674 at Zembo. according to the petitioner, he was arrested because he has been named as the person to receive the consignment. By one Mr. Thang Tin Kapa, son of Ngin Dova, resident of Ramlun North. Who, during interrogation, had stated before the excise personnel that the petitioner would be receiving the contraband articles. That was seized. Now, accordingly, excise case number EX-N-41/2026 under section 22(c) of the ND-NPS Act was registered and investigated into. Stop. The petitioner contends that ever since his arrest on 6/3/2026, he has been kept in custody till date. Stop. Next para. The learned counsel for the petitioner submits that the petitioner has sought for grant of bail on the ground that there has been gross violation of section 47 and section 48 of the BNSS Act. Stop further. In view of the violation of the said provisions, the fundamental rights of the petitioner guaranteed under Article 22 of the Constitution of India has also been grossly violated. Stop. Referring to the grounds of arrest, prepared and furnished to the petitioner, the learned counsel submits that the same does not contain the specific ground for which the petitioner was arrested. And therefore, the same does not meet the requirement of section 47 of the BNSS. Stop. He submits that the suspected methamphetamine was not even recovered from the possession of the petitioner. And therefore, his arrest is illegal. Now, the learned counsel further submits that as per section 48 of the BNSS, intimation of arrest has to be sent to the near relative, friend, or acquaintance of the arrested person. But the same has not been done in the instant case. Stop. He submits that the arresting authority has prepared an arrest intimation wherein name of his wife has been entered. Stating that since she could not come to the place of occurrence, the intimation was given about the arrest over phone. Stop. He submits that the same does not meet the requirement stipulated in section 48 of the BNSS. Since no reason has been stated in the said intimation as to why the petitioner has been arrested, stop further. Since the wife of the petitioner resides in a different state, the arresting authority is required to send the intimation of arrest by post, which, however, has not been done in the instant case. So, therefore, the provisions of section 48 having been violated, the petitioner should be released on bail. In support of his submission, the Learned Counsel has relied upon the following authorities: : number 1, order dated, or you can write like this: number 1, Hem Khochon Tauthang versus State of Mizoram, 2026 GAU-MZ:177. Number 2, Vihan Kumar versus State of Haryana and another, 2025 5 SCC 799. Next para, the Learned Counsel lastly submits that since the petitioner has been lingering in jail since his arrest, and in view of the violation of the mandatory provisions of law, he should be released on bail. Next para, per contra, Ms. Vanesyami, Learned Additional Public Prosecutor, submits that the petitioner was indeed informed about the grounds of arrest and that he has sufficient knowledge of the basic facts constituting the grounds of his arrest, stop. At any rate, she submits that the purpose of section 48 of the BNSS is that the person arrested is made to understand the reason of his arrest and the fact that he also has a right to consult a legal practitioner to seek his bail. Stop. She submits that the mode and method of communication must be such that the object of the constitutional safeguard is achieved. Stop. She therefore submits that from a bare perusal of the grounds of arrest furnished to the petitioner under section 47 of the BNSS, the petitioner has been made fully aware as to why he has been arrested, and there is no question of there being violation of the said provision. Stop. To substantiate her submission, the learned counsel, to support her submission, to support her submission, the learned additional PP has also relied upon the case of Vihan Kumar Supra. Next para. The learned additional public prosecutor, by further referring to the case diary that she has produced, submits that from the recorded statements of the petitioner by the excise authorities, it can be clearly appreciated that the petitioner was the recipient of the said consignment, but before the same could reach him, before the same could reach him, the consignment was seized by the excise personnels. Stop. She submits that although the petitioner is a cement mistri by profession, but he has been engaging himself in the transportation of the contraband substances in the past and has also earned a handsome remuneration for doing so. Stop. She submits that although the consignment may not have been recovered physically from the possession of the petitioner, but he has the required information as to how the consignment was going to reach him, and he was there to collect the same. but for the interception made by the excise personnel. Stop. She submits that the investigations are on the verge of completion, and it is only and the charge sheet is likely to be submitted shortly before the court concerned. She therefore submits that the petitioner may not be released on bail at this stage. Next para. Insofar as the averment by the counsel for the petitioner that section 48 is violated, comma, the same is not the factual position in view of the fact that a clear intimation has been given to his wife, to the wife of the petitioner over phone the petitioner has not only provided the phone number of his wife, but also has acknowledged about the phone call made to her in the body of the arrest intimation. Of such being the case, there is no substance in the argument made by the learned counsel for the petitioner. Okay, that if you just go back to that Vihan Kumar, na, she has also relied upon the case of Vihan Kumar. Suprana. After that, you just add one more line. In addition, the learned additional PP has also placed reliance upon the apex court decision in Kasi Reddy, Upender Reddy versus State of Andhra Pradesh and others, 2025 SCC online SC 1228. Now you go back to the last sentence. The learned additional public prosecutor has also produced the case diary for perusal of this court. So the remaining part I will dictate later. Okay, will be disposed today only. Come. Chamber around. Was item number? Is it 12?
12.
Okay. We'll just take a short break and come back.
I had drafted the objection on the 18th and 19th of June and had submitted to the PWD and which had been forwarded for vetting. And I have received the copies of the vetted copy of the objections, Your Lordship. And since they're all analogous, that is RFA 47 to 51, hence it had taken time for the LNG department also to vet the same. Your Lordship, in this regard, if I may be granted another 2 weeks' time to file the written objection, and then if the matter may be fixed on the 4th of August for hearing.
4th of August. When will you file?
Your Lordship, I'll be able to file it within this week, Your Lordship.
Okay, Ms. Lalnun, who will Learned Government Advocate, submits that. She will be able to file the objection to the IA within this week and prays that the matter be listed on 4th of August for consideration. Mr. P.C. Lalthangmoya, Learned Counsel for the applicants agrees to the submission. List accordingly.
Much obliged, Your Lordship.
Item number 13.
My lord, the case diary has not been received yet. The case diary was called for, my lord, but then it has not been received
Your
yet.
Lordship,
my
I
lord.
have not received the case diary yet. So if this matter may be listed next week.
Okay, when do you want?
My lord, Tuesday.
Okay, as paid for by the parties. List the matter on 21st of July 2026. Stop. In the meantime, the Learned Additional Public Prosecutor, Ms. Vanesyami, shall requisition the case diary for perusal of this court.
My lord, if I may, my lord, case is from the Longklai. So if the case diary can be delivered with scan copy, my lord, or
She will do it needful.
We'll do that.
okay.
She'll know what to do, isn't it?
Yes,
Just to be
Your Lordship.
specific, my lord.
It's okay. Okay, should I mention?
No, Your Lordship, it's not necessary.
You produce,
So,
yeah,
yes,
you
we
produce,
will
not required.
choose scan copy only.
Obliged, my lord.
Item 14.
May it please your lordship.
Yes.
My lord, this bail application is, it is against NCB, my lord. However, my lord, today morning I was informed through the local council that the NCB is yet to file an objection and they wanted to file objection.
Yes,
If
my
they
lord.
are,
If a week's time may be granted for filing our objection.
my lord, can it be posted any date on next week, my lord, subject to your lordship's convenience?
Objection. I don't know, it depends on their objection,
Yeah, 1 week,
Which is-
we'll file within a week, my lord.
a week's time. So why not have it on 27th of August?
Yes, my lord.
Let them have some time.
27th of August.
Yes, Mr.
M. Biswas.
M. Biswas, Learned Counsel, appears for the applicant through RBC. Miss
R.K. Larinsangi, appearing on behalf of Standing Counsel, Mr. Sizoram Thana,
Ms.
NCB.
R.K. Larinsangi appears on behalf of Mr. Cizo Ramchana. What is he? Standing Counsel or Special PP?
Oh, special PP for.
Special PP NCB. And submits that the objection is under preparation and therefore prays for a week's time to file the same. In view of above, list the matter on 27th of July 2026.
Obliged.
My lord, let it be on 29th, my lord.
29, Mr. Biswas, probably there will be a division bench. So
Then on 30, my lord?
30, 30?
Yes, my lord. 30.
Okay, make it 30, huh? 30 July.
Obliged.
I'm so deeply obliged.
Item 15.
May I please, your lord. My lord, this IAF is filed for special leave to appeal, my lord, against the order passed in probate case number 13 of 23.
Special leave to appeal.
No, leave to appeal, I'm sorry. It's leave to appeal.
It's okay, if it's special also, we don't mind.
Normally, special is before the Honorable Supreme Court.
You are used to appearing there, that's why.
Now my case is to go there, my lord,
Okay.
not myself.
So this has come for the first time.
This
I
is
think.
for the first time, and
Right, Mr. Silal Faghzwala, learned counsel for the applicant, who submits that by filing this application, the applicant seeks leave to file appeal. You were not a party,
I was
otherwise
not a party.
leave to file a third-party appeal. In view of the fact that the applicant was not a party in the proceedings before the trial court. Since the matter has come up for the first time, let notice be issued to the respondent, returnable by 3 weeks. Applicant to take steps for service of notice upon the sole respondent by speed post. Can you deliver by hand or
I can do that also, my lord.
both ways?
Yes, my lord.
Speed post within 3 days. Liberty is also granted to the applicant to serve notice upon the sole respondent by way of dasti through the registry of this court. Stop the same may be done within 10 days from today. The applicant shall thereafter file an affidavit to show proof of service. List again after 3 weeks. Which one comes first? Otherwise, there's a condonation also.
Yes, this leave to appeal has to come first, my lord.
Leave has to come
Yes.
first. Okay.
Item 16.
Item 16 is also, my lord, this IA is for leave to appeal between the same parties. Now, in item 16 is regarding heirship. Item 15 is regarding probate.
Okay. So similar order.
Similar order. But the order would be different.
Similar order means the order will go on in IAC number 135 of
Yes, ma'am.
26. Okay. In the cover is written leave. In both cases, leave.
Obliged.
Item 17.
My lord, may I be allowed to make submission on behalf of my senior, Mr. Bilaram Enga?
Yes.
My lord, this application, IA Civil Number 141 of 2026, is an application for condonation of 52 days delay in...
You're not there in this case.
I'm sorry, my lord?
You are not engaged in this case.
My lord, I have not filed my vakalat nama. That is why I'm seeking
What is your name?
Latlan Louis.
Okay. Yes, yes, you may submit.
My lord, this is for condonation of 52 days delay in filing of the connected appeal.
Okay, notice will go, I think. First time.
Yes, my lord.
Heard Miss Laltan Louis, LAL, TLAL, HLUII.
HLUI, my lord.
Only I, huh? Well, not double I, one I.
Not double I, Louis.
Laltan Louis. Learned counsel who submits that by filing this application, the applicant seeks condonation of 52 days delay in filing the connected regular first appeal against the impugned order dated 11/2/2026, passed in heirship certificate case number 114 of 2026. Next para, issue notice returnable by 3 weeks. Would you like to serve by dasti also?
Yes, my lord.
Applicant to take steps for service of notice upon the sole respondent by speed post within 3 days and also by way of dasti within 10 days through the registry of this court. The applicant shall thereafter file an affidavit to show proof of service by way of dasti. List again after 3 weeks.
From admission list, item number 3.
May I please, Lordship?
Yes.
Lordship, kindly come to the affidavit in opposition filed by the respondent number 1 to 3, page number 21, Lordship. Land allotment, Lordship.
Are you going for admission hearing? Are we going for admission hearing?
Lordship, yes.
Then why do you start with the affidavit in opposition?
Lordship,
You tell me your case first. Your case is based on the affidavit in opposition.
no, Lordship.
Then,
I'm sorry. Lordship,
Yes, Your Lordship, if I may.
just a minute.
I did not file my affidavit yet. I'm representing the state government, respondent number 4 and 5,
Okay.
and I'm seeking another week's time.
Are you a necessary party or a pro forma party?
Not that much, Your Lordship. We are not even the performer, but we are not the main respondent.
This is the case of 2025. Why you have not filed affidavit till now? Yes, Mr. Chakma, you are praying for what, compensation?
yes, Lordship.
Your Lordship, even the respondent number 5, that is the CADC, they didn't
What happened to
file
your
yet.
land?
Lordship, as per the.
Occupied? Your land has been,
Not acquired, Lordship.
Not
Still they are in possession of my land, Lordship.
who is in possession?
By the BSF, Lordship.
BSF?
Yes, Lordship.
Which area? Where's the area?
Barapansuri, Lordship.
Barapansuri.
Yes, Lordship.
Since when?
Since 1969, Lordship.
And you're coming now?
It's all, Lordship, there is also similar judgment also, Lordship, in regard to this. And Lordship, this honorable court last time allowed to file my additional documents, Lordship.
You have filed already?
Yes, Lordship.
What are the additional documents?
Lordship, additional documents, it's in page Annex 3, Lordship.
No, tell me, what is it?
May I read, Lordship?
What are those?
Lordship, in pursuance to Rule 4 of the Chakma Autonomous District Council, Land and Revenue Act 2002, the Executive Committee of Chakma Autonomous District Council is pleased to notify for general information that all land allotment made under Sub-Rule 5 of Rule 4 of the Chakma Autonomous District Council Agricultural Land Act 1982 shall stand cancelled with immediate effect due to certain technical reasons, Lordship. Their only contention is that, Lordship, they said that the CIDC have given them freely.
What has been given freely?
The land is given freely by the Chakma Autonomous District Council
Okay.
to the BSF, Lordship.
It was freely given to you.
To the BSF, Lordship.
Oh,
My land given to the BSF, Lordship.
Okay, your land has been given freely to the BSF?
Yes, Lordship.
By which letter?
Lordship,
By which order?
the one, Lordship, kindly come to page.
Now, you are in possession of your land by virtue of what kind of pass or anything? Any
LSC, Lordship. Earlier, it was temporary pass.
Uh-huh.
I have temporary pass, and from temporary pass, I have given my taxes thoroughly, Lordship. Thereafter, temporary pass was converted into LSC, Lordship. Till then, I am paying my taxes till date, Lordship.
Conversion happened while the land is still in possession of the BSF.
Yes, Lordship.
They are in possession, you are changing the pass from this to that, like that. That's possible.
No, Lordship.
Then,
Earlier, it was in temporary pass. And from temporary pass, my pass was converted into LSC.
no problem.
Yes.
Permit, temporary pass,
And-
LSC. That process goes on like that.
Yes,
But
Lordship.
what I'm asking you is that
Lordship.
possession of that land was in 1969, you said?
Yes, Lordship.
That time you had what? Temporary pass.
That time it was my father pass, Lordship. My father. And
Okay, your father's pass was a temporary pass.
not my father was LSC, Lordship.
Oh, LSC.
LSC, yes.
Then it's reverted back to temporary pass.
And from that pass, Lordship, from that pass, it's divided into various portions of land, Lordship. And my father, he got his compensation earlier as per the earlier judgment, Lordship. He got the compensation. That was no dispute, Lordship.
Okay.
Now only my contention is that the BSF, they are occupying my land forcefully since 1969, and in that portion, Lordship, I am paying my taxes. And as per the contention of the BSF is that, Lordship, my land was given freely by the CIDC.
So that is why you
That
were
is
pointing.
null and void, Lordship.
No, that is why you were pointing out something in the affidavit of opposition.
Yes, Lordship.
Let
yes.
us see. Let us see. Where is it? 1 to 3.
Page 21, Lordship.
Respondent 1 to 3.
1 to 3, Lordship.
Page
21, Lordship.
land allotment.
Land allotment, Lordship. May I
Yes, read.
Under subsection 5 of the Chakma Autonomous District Council, Agricultural Land Act 1983, the Executive Committee of the Chakma Autonomous District Council is pleased to allot the land prescribed here under to the BSF Barapansuri. Schedule of the land area 29,042 square meter. Location Barapansuri. Boundary is WRC land of Virasmoni Chakma, that is my father, and west streamlet fencing. North WRC land Reboti Mon Chakma, south Barapansuri stream old. My lord, if you come to the signature part, Lordship. No official signature, Lordship. No official signature, no official seal, and the round seal of the CIDC, Lordship.
But so from this document, it was given to them, rightly or wrongly, that plot of land was given to
Yes,
them.
yes, Lordship.
So by virtue of this land allotment, they are occupying.
They are occupying, Lordship.
And where is your pass in your case?
My father is Lordship.
31,
In my writ petition, Lordship.
page 31. This is LSC.
LSC, Lordship. Yes, Lordship. Page 31.
What is the boundary?
Boundary 30,000 square meter, Lordship.
Boundary is not area. Boundary is boundary. East is Borapunsuri streamlet. Borapunsuri streamlet.
Yes,
Then west is WRC land of Reboti Mohan.
yes, Lordship.
Reboti Mohan is also there in the BSF permit.
Yes,
West.
west.
Then on the north,
WRC.
own WRC land, football ground.
Yes, Lordship.
What does it mean?
That said, earlier it was football ground, Lordship. That football ground is my fatherland, where the BSF legally occupied, Lordship. And in that land, they paid the compensation also.
No, why it is written own WRC? Is it like that?
It's like that, Lordship.
This is a typed copy or what?
This one is type copy, my lord, yes.
Where is the original
The
copy?
original copy is page number 34, Lordship.
34.
Yes.
Own WRC land, okay. Football ground. Then south is Borapansuri streamlet. Streamlet.
Streamlet, Lordship.
These area of land seems to be quite adjacent to each other. If not the same land or what? So your LSC is of the year 2008,
Yes, Lordship.
correct?
Yes, Lord.
And then this has been converted from pass.
From past, yes, Lordship.
Is it given anywhere in this LSC?
Yes, Lordship. I have annexed in.
No, in the body of the LSC, normally they write, na, this has been converted from so and so pass like that.
No, Lordship, it is not written.
It is not written here.
Yes, Lordship. But as per the record, Lordship, it's in page number 28, Lordship. Writ petition page number 28.
28.
Yes, Lordship.
28 is what?
The revenue receipt, Lordship. I lost my temporary pass, Lordship, but somehow I have the revenue receipt, Lordship. Lordship, on this one, on fourth paragraph, that is garden tax for 1990. First number is 18/88.
18
Dated 11/8/1888. This one is the temporary pass.
This is also 1988, but you are talking about 69.
'69 was earlier, this one, Lordship. That is in Annex 1, Lordship.
Annexure 1.
Annex 1.
What is Annexure 1?
Annex 1, this one is my fatherland. Whole area of my fatherland, Lordship. That time it was 21 hectares, Lordship. And from.
Your land has been carved out of your father's land.
Yes, Lordship.
Is it?
Yes, Lordship.
Area is
That time it was 21 hectares, Lordship.
hectares something pakhat. Okay. Now your land is how much area?
My now, Lordship, 30,000 square meter.
And as regards the garden pass,
Yes, garden.
same thing, 30,000 square meters.
Yes, Lordship.
If you convert that into hectares, how much will it be? You have not done so. Now, how much land has been retained by your father, for which he has received compensation?
13,797, Lordship. There is an exact two, Lordship.
Your father's land,
Yes, Lordship.
13,000.
Yes, Lordship.
Oh, you've got the larger portion.
Lordship.
He has taken 13,797.
Yes, Lordship.
And you
these
have
were-
taken 30,000.
Yes, Lordship. And yes, Lordship. And this land already given compensation, Lordship, prior to that.
It's like land is divided into 4 parts. Your father has taken 1 part, you have taken the 3 parts.
My brothers also, they have taken other parts, Lordship. Other portion.
But you see,
And Lordship, as per the record, Lordship, even the CIDC also denied that they have given the land to the BSF.
who has denied?
By the CIDC, Lordship.
Have they filed anyone appearing for CIDC?
Not yet.
No, Lordship.
Then how do you say that they have denied?
Lordship, as per the RTI, Lordship.
Oh, RTI is one thing, but let them also appear here. Let them say what is what.
Right.
Earlier, this honorable court referred the matter for mediation, Lordship. And in that mediation, Lordship, the BSF categorically stated that export verification need to be done, Lordship, in order to get the correct figure, Lordship.
Okay, anyway, first thing first. Now, since this land allotment has come and you have got your own allotment, they have got their own allotment. Who is allotted what and who was allotted and who has been compensated will have to be looked into. Now, as regards Ms. Jairam Sangpu, you are for 1 to 3, correct?
Yes, I already
And
filed my affidavit.
CADC, who they are respondent numbers?
Respondent number 5.
5 only. And Ms. Vanessiam, you will represent 4. What is your instruction otherwise? Or from your part, on your part, you're taking time only? They have not informed you to take time. Sorry, you've sent a letter. But this is basically between the CADC and the, what do you call the BSF.
May I please, Lordship? I'm sorry to interrupt. My Lord, this matter is only mostly between the BSF and the private owner, Lordship.
Yes, you are repeating what I'm saying. That's what I'm saying only.
Yes, Lordship.
It's between the BSF and yourself
Yes, Lordship. And Lordship, this in order to
and the CADC.
No, CADC is the most important necessary party in this case, my lord.
They're already a party here. The question is, whether have they appeared? Notice has been served or not?
notice has been served, Lordship. Dusty or the Dusty.
When? Did they appear in the mediation?
Yes, Lordship.
They come. They had come.
Lordship, this matter need to be do the export verification, Lordship. Generally, it will be. Lordship, the BSF they agreed to go for mediation to go for export verification, Lordship. Lordship, may I place the mediation order, Lordship? If you
You're not
Mediation
required.
fail. That is
Not
why they
required.
return to here.
And in the affidavit filed by the respondent, Lordship, they said that the CIDC did not inform the respondents that they have issued the notification, Lordship, for cancellation of the.
Have you filed the Dusty affidavit? Dusty affidavit. Who has received it? Land Revenue Cell.
Revenue Department.
Okay. They don't have a standing counsel?
I'm not aware, Lordship.
You take steps once more, along with the order of this court. How would you like to take, by way of Dusty or by speed post? Dusty. Please write, Heart Mr. B. Chakma, learned counsel for the petitioners, Ms. Zaidam Sankui, learned CGC for respondent numbers 1 to 3, and Ms. Vanna Isyami, learned government advocate for respondent number 4. No one appears for respondent number 5, despite notice being served by way of Dusty. On 30/9/2025. Stop. This court has been informed that the matter was sent for mediation, but mediation has failed. Stop. It has, however, submitted that during the mediation, the respondent number 5 was represented. So, however, no one appears for respondent number 5 today. Next para. Claim of the petitioner is that his land has been illegally occupied by the BSF authorities since the year 1969. Despite the fact that the petitioner is in despite the fact that the petitioner has been issued LSC number 6 of LSC number 6/91 dated 9/7/1991 by the respondent number 5. Stop. The learned counsel for the petitioner submits that the father of the petitioner was initially allotted pass number 26 of 1957 dated 6/11/1957, covering an area of 21 hectares, along with the boundary description given therein, bracket annexure 1. From the said pass, the land has been subdivided into various parts, and the petitioner came to be issued pass number 18 of 1988 dated 11/8/1988 for an area of 30,000 square meters. Stop. The pass was then converted into the LSC. Stop. According to the petitioners, since their lands have been illegally occupied without permission from the petitioner by the BSF authorities, they should be given due compensation for such illegal occupation. Stop further, if the land is required by the BSF authorities, the same should be acquired in accordance with the relevant acquisition law. Next para, the respondent numbers 1, 2, and 3, bracket BSF, have filed their counter affidavit on 4/8/2025, wherein they have annexed land allotment made in favor of the BSF by the revenue officer, bracket headquarters, Chakma Autonomous District Council, Kamala Nagar. Stop. The said land allotment states that the executive committee of the Chakma Autonomous District Council allots has allotted land to the BSF at Borapansuri for an area of 29042 square meters, bracket 7.10 acres. In Borapansuri. Under the provision, this is also not very clear. No? Subsection 5 cannot remain by itself. Subsection 5 will be part of some section. What is that section?
Section 4, subsection 5.
But it is not written here, isn't it? Under the provision of the Chakma Autonomous District Council, bracket agriculture, close bracket Act, 1983. Stop. The learned counsel for the petitioner, Mr. B. Chakma, on the other hand, submits that the said land allotment is highly doubtful because it does not bear the seal and signature of the issuing authority. Stop. Under this circumstance, in order to get to the bottom of the genuineness of the said pass, the respondent number 5 will have to give a response in the matter. So therefore, the petitioner is directed to once again serve notice to the respondent number 5 by way of Dasti through the registry of this court within 15 days. 1 week?
1 week.
Sufficient?
Sufficient.
Within 1 week from today, and thereafter file an affidavit as proof of service. The case shall now be listed again. On 10th of August for further consideration. Okay, let's see.
From the obliged.
Item number 4.
On behalf of the leading counsel, Mr. Rajiv Chanpan LB, he could not appear due to personal difficulties. If your lordship may kindly allow us 1 week
What are you saying?
The leading counsel, Mr. Rajiv Channapan Nalvi, could not appear due to some personal difficulties today.
Okay. So,
So if this matter may be taken after a week.
after a week.
Yes, Your Lordship.
Now, what about the respondent?
Lordship, I'm representing all the respondents.
Your name is not here.
Lordship, yes, not there. I'm the standing counsel for the CGST.
Your good name?
Daniel Ramrotki Mashasel.
Mr. Daniel Remruatki Mahrasel, learned counsel for the petitioner, submits that he is led by Mrs.
Mr. Rajiv,
This is Mrs.
Lordship, this may be an error.
Led by Mr. Rajiv Channappa Nulvi,
Yes, Your Lordship.
learned counsel in the matter. And since he has some personal difficulties to appear before the court today, he prays that the matter may be adjourned for a week. He may be listed again after a week, not adjourned. May be listed again after a week. Any objection?
Lordship, I have no objection, and in the meantime, I may be allowed to file counter affidavit, Lordship, to the effect.
And how much time will you require for counter affidavit?
2 weeks, Lordship.
Mr. Johnny L. Tochong, learned counsel, learned standing counsel,
Yes, Lordship.
CGST,
CGST.
submits that you may be granted 2 weeks' time to file counter affidavit. Stop in view of above, list the matter. Again on so and so. We'll give a date. Today is what, 23rd? No, today is 16. When do you want it?
Lordship, maybe 6th of August.
This lady, she'll come in person or through
We will be
RBC?
appearing through VC.
VC.
Yes, Your Lordship.
When do you want it?
6th of August.
Okay.
Your Lordship, in the meantime, the interim stay order may be continued.
In view of above, list again on 6th of August 2026. Respondent to file counter affidavit in the meantime. Registry shall reflect the name of SC CGST in the cost list, and also correct the name of and also affix within inverted comma Mr. close inverted comma against the name of Rajiv Channappa Nulvi, counsel for the petitioner. The interim order passed earlier shall continue till the next date of listing.
Thank you, Your Lordship.
We'll come back in the afternoon. Fresh process has started again.
I don't think so, Your Worship.
What is the name of the post?
Sericulture demonstrator.
Demonstrator. They say that you are not qualified.
No, Your Worship, it's, the dispute is regarding
The process.
the selection process. There were some irregularities. Some candidates had taken their mobile phones into the examination hall.
How many petitioners are here?
4.
So cancellation is only on the 4 petitioners.
No, I mean, the entire selection process was cancelled and the appointment of the petitioners. So it was decided to,
How many were appointed? Only 4.
for only 4. The decision was taken to conduct the selection process afresh. So we are challenging the decision to conduct the selection process afresh. Mainly on the ground, Your Worship, that, I mean, those tainted candidates who were involved in any illegalities can be segregated. There's no requirement to cancel the entire selection process. Because the inquiry reports clearly mentions those who were guilty of carrying their phones, mobile phones into the examination hall.
Mr. A.R. Malhotra, learned counsel for the petitioners, and Mr. Samuel Balaji Tatsante, learned additional advocate general appearing for the state respondents, submits that pleadings are complete. The matter may be taken up for admission hearing on 21st of July 2026. Accordingly, registry placed the matter on 21st of July for admission hearing.
Item number 7.
But it is a regular second appeal from the judgment and order in RFA number 11 of 2021. Lordship, there was a delay of three days, which was earlier condoned by this honorable court, and now the appeal is by Lordship. Lordship, I have taken several grounds.
This is a second appeal, so
Second
what is the substantial question of law involved?
Your Lordship, the substantial questions of law which I have proposed at page 13, start at page 13, the paragraph 4. Your Lordship, may I read?
Yes.
In view of the above, the following substantial questions of law are found to involve in this appeal. Number 1, whether the Learned First Appellate Court was right in upholding the judgment and order, along with the decree dated 18/10/2021, passed by the Learned Trial Court, conferring right and title over the land under P. Pata number 377 of 1978 in favor of respondent number 1 on the basis of Mundin Pekna Lekha, that is gift deed, dated 27/6/2002, allegedly made by Sri Langena long after his death on 15/4/1980. Lordship, in this connection, the land under P. Pata number 377 of 1978 was in the name of late Langena, and Langena had died on 15/4/1980. And this gift deed, allegedly made by Langena in the revenue records, was made, and this on the basis of this in Pekna Lekha, dated 27/6/2002, the transfer, mutation of the land under P. Pata number 377 1978 was made in favor of the respondent number 1.
Okay, Mr. Hamza, one thing. Anyone has appeared for the respondent
These
in
are-
the delay condonation?
No one appeared.
Notice was served.
notice was not served because it was only three days, and the Honorable Court was of the view that since the delay was due to the fact that we had submitted an application for certified copy on a particular date, and during that period, when it was pending before issuance of the certified copy.
Okay, what was done was done. We'll issue notice now.
Right.
Let them come. Heard Mr. Siloram Zawal.
Lordship, I have one more additional substantial question of law, which I would like to propose.
You may submit that separately if you want.
All right.
Mr. Siloram Zawal, Learned Senior Counsel, assisted by Mr. Stephen Lal Buatsaya for the appellants.
Appellants.
Oh, appellants.
Two appellants, sir.
Who submits that being aggrieved with the judgment and order dated 1/4/2026 passed by the Court of Additional District Judge, Aizawl, in RFA number 11 of 2021. The appellants have preferred the instant regular second appeal by invoking section 17(2) small b of the Mizoram Civil Codes Act, 2005, read with section 100 CPC. Let notice be issued. Appellants to take steps for service of notice upon the sole respondent by speed post within 3 working days. List the matter. Did I say returnable date? List issue notice. This place is what?
Mualungthu. Location is at Mualungthu.
Mualungthu?
Yes.
No, the respondent resides in Mualpui Police
Respondent is at
Complex.
Mualpui Police Complex.
Can you serve by Dasti?
You can do it.
It will be easier for you. I mean, things will move faster because again we have to wait whether received or not and all that. If you give by Dasti, petitioner to take steps, appellants to take steps for service of notice upon the sole respondent by, I said, 3 working days, na? Stop. Additionally, the appellants to take to serve notice to the sole respondent by way of Dasti through the registry of this court.
It's not sole respondent. Respondent number 1.
Oh, I see.
It's the plaintiff. There are some other.
The other official respondents.
The official respondents are 2, 3, 4, 5, and 6. They're all official.
Okay, let's go back to the thing. Issue notice, na? Issue notice returnable by, today is what, 20, 15, 16. Returnable by 10th of August 2026. Who appears? Miss Mary. Miss Mary L. Kianka, Learned Government Advocate, accepts notice on behalf of respondent numbers 2, 3, 4, 5 and 6. 2 to 6. Huh? And therefore no formal notice is required. Appellants shall, however, furnish requisite copies of the memo of appeal to the Learned Government Advocate within 3 working days. Stop. Appellants to take steps for service of notice upon the respondent number 1 by speed post within 3 working days. Stop. Additionally, appellants are permitted to serve notice to the respondent number 1 by way of Dasti through the registry of this court. Stop. The same be done within 10 days from today. Stop. Appellants shall thereafter file an affidavit to show proof of service. List again on 10th of August.
Item number 8.
One more line. The appellants are also given liberty to file additional substantial questions of law by way of an additional affidavit, if so advised.
May it please your lordship.
Yes.
Your lordship, I'm appearing for the petitioner in WPC 27 of 2026, and a connecting IA has been submitted by me. The reason for submission of the IA is because there has been a development. The WPC is submitted for challenging a cancellation order for cancelling my LSC. And while it is in sub judice, there has been the Deputy Commissioner of ISOL has issued an eviction notice. So therefore,
Where is the location?
location is in Turiel.
Turiel.
Yes.
Why have you been evicted from this?
It is maybe because a notice service has not been completed yet in the WPC.
No. Why have you been evicted? Why has your LSC been cancelled?
LSE has been cancelled due to the fact that alleged that the LSE is within the boundaries of the RRF, Riverine Reserve Forest area.
Who's respondent number 5?
Respondent number 5 is Kala.
Hold on. Your land has been acquired.
Yes, Your Lordship. It has been acquired
When? By which award?
by the NH54. I'm sorry, Your Lordship, I didn't.
How is your land acquired? By which document? Any document to show that your land
Your
is
Lordship.
acquired?
There has been issued for a 3G notification, and our land has been included there.
Where is that? One way you say your LSC is cancelled, other way you say its land is acquired, and thirdly you say you have been evicted. If your land is acquired, then you have no right to stay there.
Not all of the land are being acquired, some parts of it.
Some parts.
Yes, Your Lordship.
But where do
The
you get
notice
those?
is in page number 28 of the WPC, 28 to 39.
28. 28 is what, the 3G award?
Yes, Your Lordship.
Where is your name?
Page number 41, if Your Lordship may go to page number 41.
41.
Yes. Serial number 34. GLSE W19 of 1985.
Serial number. It's the name of your mother,
Yes, Your Lordship.
Vantangi.
Yes.
The land is not notified in 3A, 3D, 3G in the previous notification. Missing plot. Since the construction of road affected the assets of the landowner, asset value is to be compensated. So what is this? Is it some remarks given here?
This is a
Since-
supplementary award for NH54.
Since the construction of the road affected the assets of the landowner, asset value is to be compensated. You are to be compensated for the asset value.
Plus the land value. But it has only been
So,
written here, asset
what-
value.
Huh?
It has only been written asset value only, but as per law, we are to be compensated for the land value as well.
So let them file their affidavit. What is there now? Be done. What can be done?
Your Lordship, I'm seeking for an ad interim order on the operation of the eviction order.
When did you file your IA?
I was filed on 2nd of,
2nd July.
yes, Your Lordship.
Court master, the same mistake has been made. See, when they file an IA, fresh IA, it should come first. It's hanging below the writ petition. It should come first, so that we know what is what. Please instruct. Give me the IA. Oh, it's here. It's here. Miss Mary,
Yes, Your Lordship.
they want to stay.
Your Lordship, since they were not included in the facts of the case is that they were not included in the award at first. However, upon their request, assessment was made and it was verified, and later it was found that their land was marked as a missing plot. And supplementary award is not yet issued, Your Lordship. They have made an assessment. As per the averments, I'm referring to the averments made by my learned friend in their petition. It's for the supplementary award that the assessment was made, which they have procured it through RTI. But in this regard, if I may be allowed to take instructions on the application, Your Lordship, because I do not have a full-fledged information.
On which application? This
The
stay.
stay application, yes.
It's come for the first time.
Yes, it's coming up for the first time. So before any interim order is passed, if I may be granted time to obtain instruction.
What is there in your land as of now? Any construction?
Yes,
Any house?
There's a house, and we have planted a lots of tea tree, which is highly valuable. Tea tree and
Anybody
coffee.
living there in that land? Or it's a forest.
It's not a forest. Someone is living there.
Someone's living there.
Yeah, my brother. So, Your Lordship, if the eviction is not stayed, there is a grave danger that we may lose our house, and there will be an irreparable damage to us. And
How do you know that you have not already lost your house? This order was passed on 24th of June. You are supposed to vacate within 15 days.
15 days.
yes, Your Lordship,
If you count 15 days, I think today we are on.
I have personally
16.
consulted with the DC. I went to his office, and because there was a holiday in between, so I asked a favor of him not to take any development or operation.
In the writ petition, you have challenged the cancellation order.
Yes, Your Lordship.
Correct.
Yes.
Where is the cancellation order? Page
73.
73. Is that correct?
73 of the writ petition.
The order is passed by the Undersecretary Revenue.
Yes, Your Lordship.
And LSC number is what? W19.
W19 of 1985. Garden LSC.
You have not received any instructions in this? The writ petition?
No, Your Lordship.
1st of April notice was issued.
Yes.
What is your good name?
David Maswamkima.
Please write. Heard Mr. David Malswamkima, learned counsel for the applicant, who submits that by filing this application, the applicant seeks the stay of the eviction order dated 24/6/2026, bracket annexure 1. Issued by the district magistrate and deputy commissioner, Aizawl district, Aizawl. Stop, he submits that. As per the eviction order, the applicant has been directed to vacate his land covered by W19/1985. Okay, before that you write, before W you write LSC number W19/1985 within a period of 15 days from the date of receipt of this notice, of the notice. When did you receive this notice?
I have to communicate. I am not exactly sure the exact date.
Any statement to that effect has been made in your application? When you have received and all that? Stop, huh? The learned counsel submits that the eviction order has come while the writ petition filed by the applicant challenging the cancellation of the LSC number W19 of 1985, white order dated 12/2/2026 is sub judice. Next para, in view of above, issue notice returnable by. When can you get the instructions?
Your Lordship, by Tuesday, possible.
The instructions means you should file something. You should file
Okay.
an affidavit.
In that way, in that case, Your Lordship,
We'll grant you 2 weeks' time.
yes, Your
Okay. Returnable by 3rd of August 2026. Miss Mary Alkiante, learned government advocate, accepts notice on behalf of the respondents. All the respondents?
2 to 4, 6, and 7, Your Lordship.
Respondent numbers 4, 6, and 7. And who is else? Who is there? While Mr.
On behalf of my senior CGC for respondent 1.
Lian Ming Tanga.
Yes, Your Lordship.
While Mr. Lian Ming Tanga, learned counsel, accepts notice on behalf of Miss Zairem Sangpui, learned CGC, who will be representing respondent numbers. Only one.
Yes, Your Lordship.
Respondent number 1. Stop. Mr. Samuel Balashid Sangte, learned standing counsel, NHIDCL, also accepts notice on behalf of respondent numbers 2 and 3.
Notice will have to go to 5.
Applicant to take steps for service of notice on the respondent number 5 by speed post within 2 days. Extra copies of the application be furnished to the learned counsels appearing for the respondents today within 2 days. Learned government advocate as well as the other counsels to obtain instructions in the application for stay by the next date. I gave you the returnable date, na? 3rd. When was that? 3rd? List accordingly on 3rd August 2026.
If I may interrupt Your Lordship, in WPC, respondent number 5, notice has not been yet completed. So if Your Lordship allow the petitioner to.
Just a minute, you be bothered about your eviction. Till the next date, parties are directed to maintain status quo. Okay, number 5.
Service has not been yet completed.
Then?
Yeah. So if Dusty may be allowed.
Okay, in the main writ petition, as paid for by the learned counsel for the writ petitioner, notice be served on respondent number 5 by way of Dusty to the registry of this court within 10 days. The petitioner shall thereafter file the affidavit to show proof of service. List again along with the IA on 3rd August.
Item number 9.
Lordship, in this matter, although pleadings has not completed yet, however, Lordship, this matter is a covered matter, Lordship. Your Lordship has already passed an order in similar like nature.
Yes, what kind of matter is this?
This is with regards to granting of additional increment to staff nurses.
Additional increment.
Additional increment.
For what? For in-service
In service.
Acquisition of higher qualification.
Yes, yes, Your Lordship.
Or your higher qualification was before you entered service.
Before entering service, there's two, petitioner number 1, she has acquired this higher qualification after service. And petitioner number 2, she has already acquired higher qualification before entering into service.
Two petitioners.
Two petitioners, yes.
So both of them that did not get the
Yes.
higher increment.
Yes.
Where is the notification by which such kind of
There's a notification
increment is
issued
given?
by the Government of India, Ministry of Health and Family Welfare. That is in page number 27, annexation number 6.
paragraph?
Paragraph number 1, B. Roman number 1.
One is not there.
Two increments, yes. The first
Paragraph 1 is not there. It starts with 2 straight away. But we might as well presume there's 1
It's
because
one,
there's A
yes.
and B. So you're covered by which paragraph? B? 1B?
B1.
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 What is your
BSc post basic. We are acquiring a BSc Bachelor of Science post basic in nursing.
post basic BSc?
Yes.
And this is for the post of nurse?
Nurse, staff nurse.
Staff nurse. Otherwise, normally what is the qualification required?
It's registered nurse and registered as per the recruitment rules, Lordship. It's 1989. After that, there's no amendment. Or it's registered nurse and registered midwifery.
No,
That's it.
no.
GNM.
The requirement is GNM.
GNM,
Correct. The qualification is GNM.
Yes.
But if you have post basic BSc,
Yes.
you should get
Yes.
two
Double
increments.
increment. Yes, a 2 increment.
And where's the covered case judgment?
Lordship, we have annexed one WPC, but however, Lordship, although we have not annexed this one, this is passed by your Lordships.
Miss Mary, can it be disposed of?
Yes, I think, your Lordship, it can be disposed of. This
You
is
will have the opportunity to verify whether they actually have that
Yes.
thing and whether they conform to this requirement of the OM. If so, they will get like that.
In WPC 110 of 2024, passed on November 11, 2024, the Lordship has passed an order, para number 5. Is similar nature, Lordship. These are with regards to the staff nurse. They have possessed a qualification of BSc nursing.
What is FR 27?
FR 27, Lordship, we have annexed the extract page that is on annexure number 5, page number 26. FR 27, clause 10, grant of additional increments with, it's same with the OM issued by the Ministry of Health and Family Welfare. Production of the
This notification is based,
Based on this FR.
office memorandum is based on the FR.
Yes, yes, Lordship.
So we'll dispose it of then. You consider and make verification and Hart, Miss H. Dalmal Swami, learned counsel for the petitioners, who submits that the petitioners are working as staff nurse. Where?
And the petitioner number 1 is working in Mizoram State Cancer Institute, Zemabok. Petitioner number 2, State Referral Hospital, Falcon.
In Mizoram State Cancer Institute, Zemabok.
Yes,
And the other one, State Referral Hospital
yes, Falcon.
at Falcon,
Yes.
respectively. And by filing this writ petition, they have sought for a direction to the respondent authorities to grant them 2 increments in view of they having the qualification of post-basic BSc as permissible under the White Office Memorandum dated 15/1/2010, bracket annexus 6. Stop. The learned counsel submits that the said office memorandum has been issued by the Ministry of Health and Family Welfare, bracket nursing section. Before that ministry, you write 1, 2, 3 words. It has been issued by the Government of India in the Ministry of Health and Family Welfare, bracket nursing section. In terms of FR 27,
27, please. 27,
bracket
10.
10.
Yes.
The learned counsel submits that, in fact, the case of the petitioners is covered by the earlier decision of this court in WPC number 110 of 2024, bracket Srimati Seelal in Pui and 8 others versus State of Mizoram. And 3 others, close bracket, and WPC number 17 of 2025, open bracket, Srimati Emmanuel Lal Thazwali and another versus State of Mizoram, and 3 others. These are the 2 judgments. Okay, you can get it. She therefore submits that the instant writ petition may be disposed of in similar lines. Next para, Miss Mary L. Kiangte, learned government advocate, to see as to whether they are indeed covered by the office memorandum dated 15/1/2010. Next para, considering the above submissions, the writ petition is disposed of at the motion stage itself by directing the, I think you should all submit some.
We have already submitted our representation, Lordship,
Where?
but it's
Where?
Your Lordship, the stage is not, with due respect, Your Lordship, it's not motion, it's admission stage. Admission stage, Your Lordship.
Oh. Motion will be converted into admissions.
Annexion 9 and annexion number 10. Annexion 1 is a representation of the petitioner number 1.
That stage don't mention. This petition is disposed of by directing the respondent authorities concerned to examine the case of the petitioners to see as to whether they are indeed covered by the office memorandum dated 15/1/2010 for grant of 2 increments in view of the additional qualifications possessed by them, apart from the basic qualification that is necessary to be a nurse, staff nurse. Stop. If on such verification, the petitioners are found to be entitled for the 2 increments, the same should be given to them without further delay. And from the date they are entitled to. Such process be done no, you cancel that. The exercise of examination and scrutiny be done within a period of 6 weeks from the date of receipt of a certified copy of this order. No, you're right. The entire exercise of scrutiny and grant of the increment be done within a period of 2 months from the date of receipt of a certified copy of this order. Okay. Anything else, Miss Mary?
Deeply obliged.
Part 2 hearing, item number 1.
May it please your lordship. This is an appeal against the impugned order dated 29/20/2024, passed by the Court of Civil Judge, Senior Division 5, Aizawl District in probate case number 16 of 2024. My lord, the
Monlesa can go.
The main reason for the appeal is that the appellants, who are the son and daughter of the deceased from the first marriage, were not given an opportunity of being heard. My lord, the facts of the case is that the grandfather of the appellants.
Just a minute, Mr. Dharamchand. Let me just read myself.
Yes, sir.
property belongs to heir Nuna, correct?
Yes, my lord.
And he had executed a will
Yes, my lord.
distributing the properties, but the will was not probated,
Yes, my lord.
and there was no heirship certificate.
Yes, my lord.
And his son, Chong Rou Liana, father of the present appellant,
Yes, my lord.
executed a will
Yes, my lord.
giving the property to the respondent.
Yes, my lord.
Respondent is the second wife, I think.
Yes, my lord.
Death of Chong Rou Liana, the respondent applied for probate, and the will was probated.
Yes, my lord.
That is how you are here.
Yes, my lord.
Appellants are the children of Chong Rou Liana
Rou Liana.
from the first wife.
Yes, my lord.
That is your case.
Yes, my lord.
So how do you say that the thing should go to you?
My lord, since as per our contention, since Chong Rou Liana did not obtain any heirship or claim inheritance during his lifetime, he could not have executed the said will, which was probated by the
You're traveling back in time.
Yes, my lord. And the second ground is that since we are the children of the deceased Chong Rou Liana, even though he executed the will, we will not be left behind because we are the only children of Chong Rou Liana. And since we are also an interested person in the property in issue, and the respondent knew very well that we exist. However, she chose to publish a newspaper publication in Zolkopui, which was not even heard of by the respondents.
Zolkopui, where is that?
Zolkopui, I
in
don't
the
know.
border side.
Zolkopui newspaper. And
so you're saying that conveniently it was published in some unknown newspaper.
yes, my lord.
Okay.
Even myself, I've come to heard of this newspaper for the first time after taking up this case.
Now, this property is in Zarkot.
Yes, my lord.
Who's staying there now?
It's vacant actually right now. Some are renting it, but no one is. The petitioners or the respondents are not occupying it.
Vacant means there's a building there.
There's a building. The building is
And who's taking the rent?
the respondent is taking the rent on the basis of this will.
On the basis of that will,
order.
probated.
On the basis of this order.
And the LSC is in name of?
LSC
Heir Onhuna.
Heir Onhuna, my lord.
Still?
Yes, my lord, to my knowledge.
Yeah. So let us go to the grounds. How have you formulated the grounds?
My grounds is at page 4, my lord. If I may be allowed to read it out, my lord.
From number 2?
Number 2. For the London Trial Court has failed to see that the will dated 11/8/2022 is in and will inasmuch as the deceased Chong Rou Liana has no right to dispose of the property mentioned in the said will, that is LSC number 90 of 1971, along with the building standing thereon, since he is not the owner of the said property. In this connection, it is humbly submitted that the property that is LSC number 90 of 1971 located in Zarkot Aizol is the property of the deceased Heir Onhuna, late, who is the grandfather of the appellants. Though the said Heir Onhuna had died, neither of his sons, namely Chong Rou Liana or MS Dong Liana, had claimed inheritance of the said property during their lifetime, and the will left behind by Heir Onhuna has not been probated till date, since inheritance was not claimed by the said Chong Rou Liana during his lifetime from the competent court declaring or acknowledging him as the legal heir of Heir Onhuna. He has no right to dispose of the said property by executing a will dated 11/8/2023. Therefore, the impugned order dated 29/2024 is liable to be set aside and quashed. Number 3, for that the London Trial Court in fact in probating the will dated 11/8/2023 without issuing any specific notice to the appellants who are interested parties in the property in issue. In this connection, it is humbly submitted that the appellants who are the son and unmarried daughter of the deceased Chong Rou Liana have the right to defend the estate of their deceased grandfather in respect of the property covered by LSC number 90 of 1971 located at Zar before the trial court. As such, the impugned order dated 29/2024 is liable to be set aside and quashed. Number 4, for that the appellants were not aware of the notice published in the news in the Zolkopui newspaper, and though the respondent clearly knew the fact that the appellants were interested parties, she had played fraud upon the court by not making them a party in the probate case number 16 of 2024. Therefore, the impugned order dated 29/20/2024 is liable to be set aside and quashed. Number 5, further the appellants also dispute the said bill dated 11/8/2023 inasmuch as they are of the considered opinion that their father could not exclude them from his will. In fact, to the opinion of the appellants, the said will is not free from fraud and coercion. A perusal of the said will dated 11/8/2023 also goes to show that there were several overridings which cast serious doubt upon the appellants. Therefore, the probate for will dated 11/8/2023 by impugned order dated 29/2024 without affording the appellants any chance is based in law, and as such, the impugned order dated 29/2024 is likely to be set aside and quashed. For that, in any view of the matter, the impugned order dated 29/2024 is likely to be set aside and quashed.
What about your mother?
My mother, she is not claiming, she is remarried, so she's not claiming anything, my lord.
There's some mistake committed here.
Yes, my lord.
The cost title at page number 2. Shri Joshua Vanalpeka, daughter of Chong Roliana.
My lord,
Son of.
Son of.
Should be son of.
I apologize, my lord. It should be son of, yes. Page number 2.
How was the probate handled?
The
Probate
probate
case?
was handled.
Let us see the impugned order.
The impugned order is just after the index, my lord. If I may be allowed to read, my lord. This is a probate case filed by Srimati Vanal Swami, wife of Chong Rauliana, late resident of Chan Mari Aizol, Mizoram, to probate the two Rauchia deed of will made by Chong Liana, late dated 11/8/2023 in respect of his immovable property, that is landed property under LSC number 90 of 1971 located at Zarkot Aizol, Mizoram, wherein Chong Rauliana executed his will in favor of C. Vandala Swami, stating in his will that I'll read the translated version, my lord.
No, you read the vernacular.
Thurauchia. Kay Chong Rauliana, son of Ero, Huna, late Zarkot Aizol, Hian and Wayami ang Hian, Thurauchia, Kasiama, He Thurauchia, he is Zankat, Mitsin Kalauto,
Toka.
Toka,
Toka ni chuan.
Toka ni Chuan, Manha Turaniang, Voin, dated 11/8/2023, Hian and Waya, Kasoyang Hian, Zarkot Aizola, and Ramle in LSC number 90 of 1971, he can receive an strong daughter of Silal Kimalay, Santurin Kadaa, Anihian at Rule Angin Naitunina Turin Mopur na Anayang.
This is a separate property.
LSC 90 of 71.
Just Vanal Song. Okay. The wife. Okay.
Wife. Respondent, Valaswang is the respondent. Okay. In Hun, LSC number 90 of 1971, Zarkotami Hikapa Ero Huna, late in Turo Siamin, and now MS Longlian Le Kaming in Nate. In Rome, joint owner.
Where is the other thing?
Page 17, Your Honor.
17. This is the doing of the computer.
Yeah, page 17.
It combines letters here and there like that. Come to page 17, second para.
Yes. In Hun, LSC 90 of 1971, Zarkotami Hikapa Ero Huna, late in Turo Siamin, and now MS Longlian late. Le Kamingin Nate in Rome, joint ownership. Allow siyang hi kanaw allow boral leta kapsor kuta onvek allow nita hetiang ani abang yan in LSC 90 of 1971 kay reng at na le nakan pisiwan at so kuta onvek ang tuma so boy tay ani lo he kuro siya hi red ku du dai ngayon ku in dated 11/8/2023 yan anem genalan dilan no na rin tum na dilapin in the ane signed by Chong Rauliana, witnesses and 2 witnesses. And it was notarized.
You are the children born from the first wife
Yes, my lord.
of this Chong Roliana. He has not mentioned you anywhere, no?
Yes, my lord. That is the reason.
What he speaks about is younger brother, or
Yes.
younger sister, or younger brother.
Younger brother.
Mm.
So in fact, as per this will also, he is not the absolute owner of the LSC number 90 of 1971. It is the joint ownership of this deceased Chong Rauliana and his brother. So the will itself makes it invalid because he cannot dispose what is not his sole property, my lord.
No, joint property, how? As per the first,
As per the second paragraph, he himself.
no, in terms of the will which was not probated, is
Yes,
it?
my lord. Yes, my lord.
The heir or Nuna, whoever,
Yes, the
he
heir
made
of-
some will earlier.
Yes, my lord.
That was not probated, but in
That
terms
was
of that will, it was jointly to be owned by the Chalro Liana and his brother,
Yes, my lord.
MS Dong Liana, is it?
Yes, my lord. And I'll read the rest of the judgment, my lord. The rest of the order. Roman 3. The applicant was directed to take necessary steps by way of publishing notice for objection in daily newspaper within the stipulated period of 15 days with respect to the said probate case. The copy of Zone copy dated 4/9/2024 is submitted in court today and the same is kept in the case record. The two attesting witnesses have also been examined today. As no one has made any objection to the probate of the will within stipulated time, this court is of the opinion that no one has an objection to probate the will left behind by Chong Rauliana. Hence, this court concludes that the prayer to probate the will be allowed. Accordingly, the will left behind by Chong Liana, husband of Sri Banat Swami, President of Chan Mari, Aizawl, Mizoram, is hereby probated.
Witnesses, there were some witnesses?
There was two witnesses, F. Lal Eng Liana and H. Lal Remsanga.
Hope is not the learned senior counsel.
He is. my
F.
lord.
Lal Lenglena.
He is.
He's the one.
Yes, my lord.
Okay.
Unfortunately.
Have you annexed the thing?
No, my lord.
LCR has been called.
No, my lord, I don't think it will be, we think it will not be required in the previous.
So what do you say? You should go back.
Your Lordship, before Your Lordship makes a decision, I just want to point out two things. In the appeal memorandum, my learned friend has said that, if Your Lordship will see at page 4, ground number 2, he says that Chong Rauliana, husband of the respondent and father of the appellant, has no right to dispose of the property mentioned in the will, that is LSC 90 of 1971, along with the building standing thereon. Since he is not the owner of the said property, in this connection, it is humbly submitted that the property, that is LSC number 90 of 1971, located at Zarkot, is the property of the deceased heir or Nuna, who is grandfather of the appellants. So he's trying to make a distinction here that the disputed property does not belong to Chong Rauliana, it belongs to the grandfather. But Your Lordship, with that regard, there's a judgment of this Honorable Court that inheritance under the Mizo Inheritance of Property Act 2014, it is automatic when the owner of the property dies. It does not mean that unless you get a certificate from the court declaring you as the legal heir, inheritance does not take place.
Justice A. Paul's judgment. Justice A. Paul's judgment.
No, Your Honor, Justice Michael. 2022, 5 GLT.
That issue can be taken up in the trial court.
You remember that case, Kaithangi and all that, Kaithuam and all what? It had gone to Supreme Court.
Supreme Court, yes.
In that also, I
Same
think
thing.
that same line was
Yes,
given.
that same line.
It is just formalized by applying heirship.
Yes,
The heir to the property gets transferred with the death of the
page 690, para 26. Para 26, if I may read, Your Worship.
Yes.
Though the learned trial court had come to a finding that there was no evidence to show that the suit property was inherited by the appellant's father from F. Lal Tranpuya, it has to be kept in mind that inheritance under the Mizo customary law or the 2014 Act would start to flow automatically with the death of the property holder. Inheritance or title to a property or properties of a person would not stand or hang on his death, and inheritance to the suit property would start to devolve automatically as per the law of inheritance applicable at the time of the death of the property holder. So it is automatically inherited. I'll read para 27 here. As such, when F. Lal Tranpuya expired on 27/11/2010, the inheritance to the property of F. Lal Tranpuya would immediately start to devolve upon the legal heirs in terms of the law of inheritance applicable at the relevant time. As per section 31, subclause 2 of the 2014 Act, the appellant's father, being the only son who was not indung, the suit property would have devolved automatically upon the appellant's father. Issuance of an heirship certificate is basically a formal recognition by the court of the devolution of property to the legal heirs by way of inheritance. So, according to the court, Your Worship, it's automatic. Now, even in this case, after his father had passed away, Chongro Uliana had automatically inherited his father's property.
Okay, Mr. Malhotra,
Yes.
if the parties decide so agree, we send it back. This will be open to you.
And now, what I'm trying to say is that at one hand, he's saying that the property does not belong to their father. It belongs to their grandfather. Then, on the other hand, they're saying that the will is fabricated and false. So, I mean, they cannot blow hot and cold. At one hand, he's saying that, no, property belongs to my grandfather. And on the other hand, he's saying, no, the will is false and fabricated. If that, in that case, one hand he's blowing hot and cold in the sense that at one hand he's saying that the property does not belong to my father, it belongs to my grandfather. On the other hand, he's saying that no, the property, yes, belongs to my father, but his will is fabricated. Can he be allowed to blow hot and cold? There's a fine distinction here.
My Lord, if I may be allowed to respond. I am raising these two grounds because there is two issues. This issue, there is one issue that if the will is not probated and since it's a joint property, whether the said Chong Rauliana can execute the will of his own is one question. And even if that issue fails, I am still the son and daughter of Chong Rauliana. So I still have a right to defend his estate. And my Lord, I have one citation of the Apex Court.
See, we'll leave that aspect. We'll just say that you are not notified, so you
Yes.
may contest the matter.
Yes, my Lord.
So basically, what you're saying is that since you are also the children of Chongro Oliana, in fact, children born of the first wife, you could not have been left behind.
Yes, my Lord.
So it is surprising that such kind of will has been prepared.
Yes, my Lord.
So in that line, I think perhaps you were showing that
Yes.
will perhaps is not correct.
Yes, my Lord. In fact,
But we'll leave this open, see.
yes, my Lord. In fact,
Not that we cannot decide, we can decide here and there also, but still it'll be better. At least you'll have one more avenue to ventilate your
In
grievance.
that case, Your Honor, a time frame may kindly prescribe for the trial court to dispose of the matter.
What according to would be a reasonable time frame?
Your Honor, there are only two witnesses to the will.
That's your side,
Yes.
his side.
we'll have to produce 6 months. Right? 6 months is a
All right.
reasonable time.
Please call the steno. Nowadays you get a condition no, which blows hot and cold. So,
One hand, he's stating that the property belongs to my grandfather. Then again, he's saying my father's will is fabricated. If he's saying that the will is fabricated, means he's accepting that the property belongs to his father, but he has been left out illegally. Swami.
Was there any attempt for mediation, by the way, in this?
Mediation,
Any possibility?
I don't know, my lord, we are open from our
Lordship,
end.
let it go back to the trial court. Let
It's
the
a
trial
small
court-
property, or it's
Yes.
a property which can be shared.
I think it can be shared if if the respondent is willing.
Let it go back to the
My
trial
lord,
court.
yes, let it go back to the trial court, then
The
it
trial
can be
court.
shared for mediation thereafter also.
Keep that option open also, because it's a win-win situation, you see. Otherwise, one just stays there without anything, the other gets gains. If the party is agreeable, there'll be nothing like it. This is item number 1, okay. At item 1, okay, of the part 2 hearing list. Heard Mr. Zoram Chana, learned counsel for the appellant, and Mr. A.R. Malhotra, learned counsel for the sole respondent. Okay, you can write appellants, huh? There are 2 of them, appellants. This appeal is directed against the judgment, against the order dated 29/2024, passed by the Court of Civil Judge, bracket Senior Division, dash Roman 4, ISO, in probate case number 16 of 2024. By which the will dated 11/8/2023, left behind by late Chong Rou Liana, who is the father of the appellants and the husband of the respondent, has been probated and thereby granting ownership of the property left behind by him, covered by LSC number 90 of 1971. Stop. Next para. The appellants contend that they are the children of late Chong Rou Liana, born out of marriage by late Chong Rou Liana with his first wife. What is her name?
Dalngai Omi.
Dalngai Omi. And that the sole respondent is the second wife of late Chong Rou Liana. Stop. The property in question belongs to Sri A. Ronuna, their grandfather, who, although had left behind a will in respect of the said property, the will was not probated. And the property is still registered in his name. Stop. Since the will of late heir Onhuna was not probated, Sri Chongrao Diana, their father, could not have made the will in favor of the respondent alone. No, in favor of the respondent alone, you can say that, okay? Since the same was not inherited by him from late heir Onhuna, stop. The appellants, being the grandchildren of heir Onhuna, equally have the right to the property in question. Stop. The appellants have also questioned the will dated 11/8/2023 on the ground that Sri Chongrao Liana could not have excluded them from could not have excluded them in the will, since they are his very own children. Stop. Therefore, according to the appellants, the will could not have been probated. In favor of the respondent. Stop. Next para. Mr. Zoram Chana, Learned Counsel, submits that the will had been probated by the respondent. No, right like this. Learned Counsel submits that the respondent had applied for probate of the will without the knowledge of the appellants, and thereby depriving the appellants the opportunity to contest the said will, the probate case. Stop. He submits that it appears that a newspaper publication was done on a local daily, which is not even widely circulated. Stop. Therefore, the appellants could not did not have any information about the application for probate of the will made by the respondent, so as to take necessary steps in that regard. Stop. The learned counsel therefore submits that the impugn order may be set aside and the appellants may be given an opportunity to contest the probate case. By remanding the matter back to the learned probate court. Next para, Mr. A.R. Malhotra, learned counsel for the respondent, on the other hand, submits that the appellants on one hand contend that the property in question belongs to A. Rohnuna, and that the will left behind had not been probated. No, you write like this, huh? Mr. A.R. Malhotra, learned counsel for the respondent, on the other hand, submits that the remaining cut submits that late A. Rohnuna left behind a will, which, however, was not probated. The Mr. Chongroliana, by virtue of being the son of A. Rohnuna, otherwise have every right to inherit the property of his father. Since inheritance of a property starts to flow automatically with the death of the property holder, as held by this court in the case of Malsom Kima and versus Lalkan Kima and others, reported in 2022, 5 GLT 685. Stop. Therefore, even without probating the will of A. Rohnuna, the Sri Chongroliana had indeed inherited the property in question. Mr. Malhotra, regarding that hot and cold, what was that? You said at one side they're saying that
Property belongs to their grandfather. And on the other hand, they're saying that the will was fabricated, false. So if they're saying that the will was false, they're admitting that the property was belonged to their father. Because otherwise, they're attacking the will, saying that it was made by fraud and coercion. But that means that it implies that they admit that the property belongs to their father. It is just that the will is false and fabricated, but which points to the fact that they're admitting that the property belongs to their father. But on the other hand, in another ground of appeal, they're saying that the property belongs to their grandfather, and their father had no right to dispose it of by executing a will. So I mean, they're blowing hot and cold.
he further submits that the appellants on one hand submit that the property in question does not belong to Chalroliana, Chongroliana, but to their grandfather, Sri A. Rohnuna. But on the other hand, they have maintained that the will left behind by Chongroliana is fabricated.
Which implies that they admit that the property belongs to their
Stop
late
that.
father.
The same, therefore, would imply that they accept the fact that Chongroliana had inherited the property. Stop. The same only amounts to taking contradictory stand, which only reveals that the appellants cannot have any claim. Appellants have no case and cannot have any claim on the property in question. Next para. From the above projection, what can be gathered is that the appellants admittedly are the children of late Chongroliana and also the grandchildren of A. Rohnuna, while the sole respondent is the second wife of late Chongroliana. Stop. The probate of the will, according to the appellants, was without their knowledge, despite being one of the contenders for the property in question, by virtue of being the children of late Chongroliana. Stop. The same, in fact, was processed without their knowledge in view of the fact that there was no wide publicity about the application for probate of the will of Chongroliana, let alone any information given to them by the respondent. Stop. Considering the respective claim made by the rival parties, this court is of the considered view that the appellants should be given an opportunity to contest the probate case. Having regard to their relation to the to late A. Rohuna and late Chong Roliana. By remanding the matter back to the probate court. Stop accordingly. The impugn order dated 29/2024 passed by the Court of Civil Judge Senior Division Roman 5 ISO in probate case number 16 of 2024 is set aside and the matter remanded back to the same court for fresh consideration by giving due opportunity to all the parties concerned, including the present appellants. Stop. Since the appellants as well as the respondent are represented before this court, they are directed to appear before the Court of Civil Judge, Senior Division 5 ISO on
Say 29th of this month.
29/7/2026. And upon their appearance, the learned probate court shall proceed with the matter in accordance with law and take a decision as expeditiously as possible, preferably within a period of 6 months from the date of appearance of the parties. So it is also provided herein that any observation made in the instant order shall not be taken into account by the probate court, and rather the probate court would take take its own decision independently without being influenced by any of the observations made herein. The appeal accordingly stands disposed of. All right.
Item 16 to 18.
I see some hesitance from your side. What is this matter? Mac appeal.
Mac appeal, Lordship, yes.
Are you all ready for this?
Yes, we are ready.
What is the matter like?
It's a private car and the policy.
You are the insurance.
Yes, Lordship.
And you are the claimant.
Lordship, yes.
Both of you go and type it out. I'll call somebody if so required, okay? You still have that bail application also. This is item number 16 to 18.
16, 17, 18.
So there are 3 cases. Okay. Why? They are analogous.
Analogous case.
One accident.
Yes, one accident. The deceased are passengers of the accident vehicle.
How many passengers are there? 9? 8?
Four passengers were dead.
Okay. It is one accident.
Yes, one.
Same vehicle.
Same vehicle.
Okay. Why have you filed the appeal?
Lordship,
Your challenge is on the liability or on the quantum?
liability.
Or both?
Lordship. Liability, yeah.
Liability?
Yes, Your
Okay.
Since the policy, the accident vehicle is a private car, and the policy obtained by the owner is the liability only policy, and no additional premium was paid to cover the passengers. So in that case, the insurance company has no liability.
What vehicle was that?
It's a private car.
Private car.
Yes, Lordship.
And the car met with an accident.
Yes,
And claim is made against the insurer of that car.
insurer and the owner.
Insurer and the owner. Insurer of the accident car.
Yes.
Okay. Did it collide with any other vehicle?
No, no other vehicles were involved.
It just ran off the road or
Yes,
something?
yes, Lordship.
So what kind of policy is that?
The policy is liability only policy.
Liability policy only.
Yeah.
Supposing you cause damage to others,
Yes,
then you are required to indemnify.
yes.
And what about the owner?
Owner is indemnified.
Owner is also covered.
Yes, owner is covered.
Owner and liability,
Owner
but
and
not the
paid-
passengers.
Owner and only paid driver.
Owner and paid driver.
Yes,
And in case of any liability against any accident, you have to pay.
if the policy is a comprehensive policy, we will liable to pay in respect of all the passengers also. But
No, I'm not talking about the passengers.
yes,
According to you, you are liable to pay only for the accident in case of, to pay to the owner, driver, and in case of third party.
yes, sir. And in this case, the premium was paid in respect of the owner and in respect of the owner driver.
Owner, driver, correct.
Yes,
Supposing the owner driver drives the vehicle and they hit somebody,
yes,
you are to
yes,
pay.
yes. I am
You are to pay compensation to
Yes.
them also.
Yes, that's it.
But you say that insofar as the passenger is concerned, that is not covered.
Yes, that is not covered.
Those who died are the passengers.
Yes,
Okay. There were 4 passengers who expired.
yes, Lordship.
Driver was not there.
Driver was there, but luckily he was not died.
Acha, he not did expire.
Yes, and even the owner was died. If I'm not mistaken, he was compensated.
Owner expired.
Yes.
Owner was the occupant of the vehicle.
Yes, among the occupants.
Among the occupants, the owner also was there. Driver also was there.
Yes.
Driver did not expire.
Yes.
Owner expired.
Yes, Lord.
And he has been compensated.
Yes, Lord.
And the remaining passengers, how many?
3.
3 of them.
3 of them.
So how many occupants? 5.
Yes, Lord.
How many were there in the vehicle? 5.
Yes, to my knowledge, there are 5.
So all these 3 have been awarded compensation. That is why 3 appeals.
Yes, that's it.
Okay. Let us go to the facts first.
Yes, Lord.
What's the story?
The brief facts of the case is at page number 3. Para number 2 of my
Page number 3.
page number 3. Para number 2.
Please read.
Yes, Lordship. The brief facts of the case leading to filing of the instant appeal is that on 9/12/2018 at around 7:30 a.m., one Maruti car, Wagonar, bearing registration number MZ01J4141, belonging to Lalram Thara of Bethlehem, Weng Aizol, respondent number 3, driven by Lal Suanama of Khatla East, Aizol, respondent number 4, which was coming from Aizol towards Lamka, Manipur, met with road accident at the outskirts of Northeast Khodongsei village, in between Ngaupa and Northeast Khodongsei village, about 2 kilometers from Northeast Khodongsei, and rolled down about 400 feet from the main road. Due to the said accident, the 4 passengers, viz. Singh Zamoy, wife of Thang Zatuam of Saron Veng, Aizol, 2. Demnuni, wife of Biak Chuan of Bethlehem, Veng, Aizol, 3. Naikimi, wife of Lal Engalet of Bethlehem, Veng, Aizol, and 4. Laram Thara, husband of Tantuami Late of Bethlehem, Veng, Aizol, succumbed to their injuries at the spot. The claimants, claiming themselves to be the daughter of the deceased, Demnuni, filed the claim under Section 166 of the Motor Vehicles Act 1988 against the appellant,
as well as the respondents number 3 and 4, who are the insurer, owner, and driver respectively of the accident vehicle. The claim was contested by the appellant by submitting a written statement. You see. It was stated in the written statement that the claim petition is not maintainable. There is no locus standi, no cause of action, and that there is non-joinder, misjoinder of necessary parties. The amount of compensation claimed is highly exaggerated and without any basis whatsoever. It was denied that the deceased died on 9/12/2018 due to rash and negligent driving of the driver of the accident vehicle. It was denied that the deceased at the time of death was 48 years, as her age, as per the PMB report, which is enclosed in the claim petition, is 60 years. It was denied that the deceased used to earn ₹800 daily. The police report enclosed in the claim petition was disputed. It was stated that the insurance policy issued by the company in respect of the accident vehicle covers risk in respect of liability only policy, act only policy. No additional premium for passenger/inmate/occupants was paid by the owner to cover the risk of passengers, inmate, occupants. It was again stated that the deceased was occupant of the accident vehicle, which is insured under private car liability only policy, and that the liability only policy does not cover the occupants, passengers, inmate of the vehicle, as they do not fall within the ambit of Section 1471 of MV Act 1988, since no other third-party vehicle was involved in the accident. Hence, the appellant company has no liability towards the claimant. Paragraph 4. The respondent number 3 also contested the claim by submitting a written statement. It was stated in the written statement that his father was the owner of the accident vehicle and that he was one of the passengers who succumbed to his injury on the spot due to the said accident. It was further stated that the accident vehicle at the time of the accident was validly insured with the appellant, and as such, the owner of the accident vehicle as well as the legal representative is not in any manner liable to pay compensation to the claimant. Paragraph 5. The respondent number 4 also contested the claim by submitting a written statement. It was stated in the written statement that he was the driver of the accident vehicle at the time of the accident, and since the vehicle at the time of the accident was validly insured with the appellant, the liability to pay compensation to the claimant is on the insurance company. That are the pleadings made by the parties in the trial court. So evidence was taken, and thereafter the Lionel Tribunal passed judgment on award, wherein the claimants are entitled. It was decided that the claimants are entitled to get compensation, and the company was directed to pay the compensation amount to the claimant. So, being aggrieved, the instant appeal has been filed. Though as many as 4 grounds have been pointed out, but our main grounds of appeal is that the policy, since the policy is liability only policy, act only policy. So, in such a case, the insurance company has no liability towards the claimant. So in this regard, we pray for setting aside of the impugned judgment about Lordship.
Who was the witness for the insurance company? Anyone?
Manager, branch manager has the post.
So where is the deposition? You have not annexed.
Lordship, the page 16. The deposition of the branch manager was annexed at page 16. And the type copy is at page 20.
What does he say, the branch manager?
Branch manager, Lordship, page 20, may I read, Lordship?
Under private car liability only policy. Liability only does not cover occupants. Does not have any liability, that much only. So, have you exhibited the
The policy
insurance
was
policy?
exhibited. Yes, Lordship. The policy.
Where can we see the policy?
Policy is exhibited at Exhibit D1. Lordship, the policy can be seen at the LCR of. It's in the LCR. Lordship.
Not LCR, we call it TCR. now.
TCR.
Exhibit,
Exhibit D1, which is at page 45.
this is TCR of which MAC appeal? We are concerned with which MAC appeal here?
G. Rosama,
Was it a common judgment or separate judgment?
separate judgment.
Okay. We are concerned with MSCT case number 6. Is it?
Yes, Your Lordship. 6 of 22.
But 6 is not here. 7. Oh, 6 is here. But why there are two numbers? Top it says 6, out here it says 1. Records. It says LCR, MAC appeal. Okay, MAC appeal. That's why, okay. Okay. This is pasted by the registry only. Okay.
The insurance policy is at page 45, Lordship.
45.
45.
Very small, minute. How do we read this now? It's very difficult. Tell us which part is the relevant portion.
Lordship.
Private car liability only
Yes.
policy.
The first pages, private car liability only policy. And the relevant portion, which is at page 4 of that insurance policy, page 4 of that. That is the schedule of premium.
Page 4.
4 of that policy.
Oh, it's very difficult. Page 4. Which portion are you reading?
There is a box loss.
Yes, which box? So many
Schedule of
boxes.
premium in rupees. B is basic TP. So the insurer paid rupees 1,850 in respect of basic TP. So deducted a TPPD cover, that is third party property damage.
I can't read.
It's
It's difficult to read.
difficult to read it. But that column saw that premium in respect of basic TP and TPP third party property damage were only paid, and additional premium in respect of PA cover for owner driver and paid driver, only those additional premium were paid. Since no additional premium was paid in respect of the occupant.
Give me your copy. You have original copy?
Even my copy is very small.
It's also very small. Page number 4, you said.
Yes, 4,
Oh,
in the same page.
in the TCR. Oh, okay. It's the same thing. You are referring to the box.
Yes, Your Lordship.
How much is paid? The premium.
Premium total is 1,900.
Give it back to him. $1,900. Can you just read the relevant portion again?
The basic TP means third party property. That is rupees 1850. And next one is a restricted TPPD cover, rupees minus 100. Total is 1750. Next one is additional. That is additional. That one is compulsory PA for owner driver. That is rupees 100.
Then below that,
Below is LL. That means legal liability. LL to paid driver. IMI 28.
okay, owner driver and paid driver.
Yes.
That much only.
Yes.
So by this, you are saying that this is the only limit.
Yes.
But what about the third party?
Third party, yeah, third party property.
Where?
That is the first one, restricted TPPD cover, third party property damage.
Okay, that first part. Restricted third party.
So the total is 1,900. So since no additional premium was paid in respect of the occupants, so the policy does not cover the occupants of the.
So how did the tribunal deal with this?
There is no specific explanation in this regard. Since it only talks about that since premium was paid, the insurance are liable. It only says like that. Yeah, premium is the amount of money paid for purchase of insurance policy. So it does not mean that payment of premium does not mean that it covers all the parties. So since the policy is a private car only liability, specific premium has to be paid, additional premium.
Do you have any authority on that?
Yes, Your Lordship.
So the issue with regard to the specific plea that the liability of the insurance company is only limited to the owner driver and the paid driver and third party
Third party, Your Lordship.
has not been specifically dealt with by the tribunal. It simply says that nobody says that there was no valid document. There was valid document. Insurance was there. They should pay.
Yes. That's all.
Without dealing about the issue on extra premium to be paid in order to cover the passengers.
Nothing was dealt with.
If passengers are to be covered, what would be the kind of policy?
Additional premium has to be paid.
Additional premium, or it should be comprehensive?
Oh, yes, it's a comprehensive.
Is it,
And
is
if-
it one and the
if
same
addi-
thing?
Yes, if additional premium is paid, it has to be covered. Or if the policy is a comprehensive policy, it will automatically cover the occupants.
Comprehensive is one thing. Additional premium is another thing. Comprehensive covers the entire thing. Additional covers only that additional premium which is being paid for the passengers or for the damage of the car. Correct?
Yes, yes. So since if the insurer opted to take the liability only policy, specific additional premium has to be paid.
How much was awarded?
The awarded amount is 17 lakhs 36,520.
What was the deceased doing?
As per the contention of the claimant, the deceased
Vegetable vendor.
vendor is
Vegetable vendor. Earning how much per month?
fruit vendor is earning around 800 per day.
800 per day.
Yes, Your Lordship.
I don't think it's 800 per day. Calculation at page 42. It says annual income is 12600 multiplied by 12.
May I, Your Lordship, in this regard, the income of the deceased was calculated as 420 rupees per day because the learned tribunal found that the income was not proof. So the learned
Correct.
tribunal.
So 12600 divided by 30 is equal to 420. So daily income is 420 rupees, 420 rupees.
Yes, that
Multiplied by 30 multiplied by 12 comes to 1,51,200. So that was the calculation.
yes.
Now, addition of 30% towards future prospect, loss of income, funeral expenses, loss of estate, then total compensation. And interest rate is 7%. This judgment was rendered on which date? 24, 18/10/24. Accident happened in 2018.
Yes, it's 18.
Why there was delay in such kind of claim? Because of COVID? No. Okay, tell me what is the authority which you wish to cite?
Lordship, the first one is Tilak Singh. The relevant portion is from the first page.
This is Supreme Court.
Yes, Lordship.
What is the citation?
2006 to SCC.
Three, four, four. Tilak Singh. Yes.
May I read, Lordship? From the judgment, the core issue involved in this appeal is whether a statutory insurance policy, statutory insurance policy is the same with liability-only policy. Under the Motor Vehicles Act 1998, intended to cover the risk to life or damage to properties of third parties, would cover the risk of death or injury to a gratuitous passenger carried in a private vehicle. Respondent number 5, Balkrishnan, had insured his scooter with the appellant insurance company for the period 7/3/1989 to 6/3/1990 for covering liability to pillion passengers endorsement of IMT 70 pertaining to accident to unnamed hire driver pillion passenger is required on the insurance policy, which may be obtained by payment of additional premium. The insurance policy covering the scooter of respondent number 5 did not contain an endorsement of IMT 70. On 23rd March 1989, the scooter was admittedly sold by respondent number 5 to respondent number 1, Tilak Raj. It is also an admitted position that the registration certificate of the scooter was transferred in the name of Tilak Raj, but no notice thereto was given to the transferor, respondent number 5, to the appellant insurance company for transfer of the insurance policy, and the insurance certificate in the name of the transferee, that is respondent number 1, with effect from 1/7/89 to 1/7/1989, the Motor Vehicle Act 1939 was repealed and the Motor Vehicle Act 1988 came into force. On 31/10/1989, one Rajinder Singh, who was riding as a pillion rider while the scooter was being driven by respondent number 1, died as a result of an accident. The respondent number 2 to 4, being the legal heirs of the deceased Rajinder Singh, moved an application under Section 166 of the Motor Vehicles Act 1988, seeking compensation for the death of the deceased Rajinder Singh. This petition was opposed by the insurance company on 2 grounds. A, that the deceased was a pillion rider and the insurance policy did not cover the liability towards a pillion rider. And B, that although the original insurer, respondent number 5, had sold the scooter to respondent number 1 before the accident, neither was any intimation of such sale was given, nor was the insurance policy transferred in favor of the respondent number 1. Respondent number 5 denied his liability on the ground that he had ceased to be the owner of the scooter prior to the accident. The Motor Accidents Claim Tribunal made an award dated 8/12/1992 and came to the conclusion that the accident had taken place due to rash and negligent driving on the part of the respondent number 1. It also held that the claimants were entitled to a total compensation of Rs 389,000. The tribunal absolved the appellant insurance company from liability on the ground that no notice of the transfer of the insured vehicle had been given to the appellant insurance company in the manner prescribed by the 1939 Act. Only respondent number 1 was held liable for payment of the compensation determined by the tribunal together with interest and cost. Respondent number 1 appealed against the award by FAO number 993 before the High Court and assailed the findings of the tribunal on all the issues, particularly its absolution of the insurance company from liability. Respondents number 2 to 4 also filed cross objections and sought increase in the compensation awarded. The High Court, by the impugned judgment, upheld the finding as to the quantum of compensation at Rs 389,000, but set aside the finding of the tribunal that the insurance company was not liable under the policy and held that the insurance company was jointly and severally liable along with the appellant for the payment of the amount of compensation determined and awarded. Being aggrieved thereby, the appellant insurance company is before this court. Lordship, the next page is that deals with there's no matter of relevancy. And the relevant portion is the page 7, the last page. Second last para.
In our view, although the observation made in Asarani's case were in connection with carrying passengers in a goods vehicle, the same would apply with equal force to gratuitous passengers in any other vehicle also. Thus, we must uphold the contention of the appellant's insurance company that it owed no liability towards the injuries suffered by the deceased Rajinder Singh, who was a pillion rider, as the insurance policy was a statutory policy, and hence it did not cover the risk of death or bodily injury to a gratuitous passenger. So in this case, since the deceased was a pillion rider, it does not cover the. Another one is Selosik, General Manager, United India versus M. Lakshmi.
This is also same thing.
Yes, same.
That Tilak Singh's case also was reflected there.
And Balakrishnan. In Balakrishnan also, but the relevant portion is at para number 21.
So I think you've made your point.
Yes, sir.
That if the policy does not cover, you're not liable.
Yes, sir.
And admittedly, the policy was only meant for the driver, owner, and the third party. So you are not liable.
Yes, sir.
And there's no clarity in the judgment about whether, despite being not covered, a gratuitous passenger can be compensated.
Yes.
Generally says that there was an insurance.
Yes.
Documents are there, insurance is there, so you should pay. You are saying that we will pay definitely if you have given extra premium for the passenger,
Yes,
we are liable.
If extra premium was
If
paid.
there's no extra premium, we are not liable.
Yes.
That much only.
Yes, that much.
So the other cases also like that.
Yes, sir, it's like that.
Okay.
All
Let
the
me hear Mr. Johnny. What does he say? He's also another insurance lawyer. He must be having something.
Yes, that's it, yes. I take lordship to the judgment and order passed by the Learned Tribunal. There was a discussion regarding the insurance policy, lordship.
Which part?
This regarding the premium.
Page?
Page, lordship, 35.
We are talking about
The judgment.
MAC Appeal 1.
MAC Appeal 1.
MAC Appeal 1.
Lordship, yes.
Page 35.
35. Paragraph
Yes.
number 17. Lordship.
17.
17.
Yes, please read.
In this instant case, the first issue is whether the claim application is maintainable in its present form and style. The present claim was filed by the claimant Sri such and such, Aizawl, Mizoram, claiming compensation for the death of their mother, such and such, in a vehicular accident. The claimant stated that on 09/12/2018 at around 7 a.m., one vehicle bearing registration number such and such, driven by Mr. Lal Chuan Omar, son of such and such, residents of such and such, coming from Aizawl towards Lamka, had made road accident at the outskirts of Northeast Kodungse village and rolled down about 400 feet from the main road. As a result, their mother, Dem Nuni, died on the spot. A case under 279/304 AIPC were registered against the defaulted driver due to his rash and negligent driving, which amounting to the death of 4 passengers. From the perusal of the insurance policy, Exhibit C12, the insured paid a premium amounting to rupees 1,900, which has been clearly reflected at the certificate of insurance, and the same was exhibited without any objection. Since the insured paid a premium and as such the insurance policy extends coverage to all the individuals who were victims of the accident, which included in the instant accident, compensation must be given to the victim. Moreover, as it can be seen in the insurance policy Exhibit C12 under Section 210 and Motor Vehicle Act 1988, it runs as follows. Death or bodily injury in respect of any one accident as per Motor Vehicle Act 1988, which implies that the deceased was squarely covered by the insurance policy. The claimants filed a case under 166 of the Motor Vehicle Act 1988 against the owner, driver, and insurance company as OP number 1, 2, and 3 respectively. There is nothing to show that the vehicle documents submitted were invalid. There is nothing to show that the claim is not maintainable in the present form and style, and the issue is decided in favor of the claimants. Also, here the learned tribunal had rightly stated that premium was paid by the owner of the accident vehicle, and the premium paid to the insurance company is 1,900, which has been clearly reflected in the insurance policy, Lordship.
The issue here is whether the claim is maintainable in present form and style.
Lordship, yes.
Correct? Now, is there any issue whether what compensation is to be paid? I think that is the third issue.
That is the third issue, Lordship.
See, Mr. Johnny,
Lordship, yes.
there is no dispute to the fact that insurance policy is there.
Lordship.
What the appellant is saying, that policy is there, but the policy is only for the driver, the third party, and the owner come driver. There is no extra premium paid. So liability of the insurer is limited to those three heads only. Here, the deceased were all gratuitous passengers. In absence of any extra premium paid or in absence of any comprehensive policy taken, we cannot be saddled with the liability. This is what he's saying.
Lordship, regarding that, presuming that the insurance policy did not cover those deceased, they are regarded as the gratuitous passengers. But Your Lordship, there is a principle of pay and recover. A principle of pay and recover is still available.
Okay, where is that? What is that?
Pay and recover means the insurance company should pay first and they have to recover.
Where is that authority?
Also,
Pay and
yes.
recover.
That is 2025 Supreme Court judgment. Sunita and others versus also the operative is from paragraph 11.
No, I think you should read from paragraph 2 first.
Lordship,
Let us
yes.
try to understand
Yes,
the
yes, Lordship,
brief actual background.
Very true, Lordship.
Yes.
The present appeal arises from the final judgment and order dated 12 December 2012 passed by the High Court of Madhya Pradesh at Jabalpur in miscellaneous appeal number such and such, which in turn was preferred against the award dated 19 December 2016 passed in case claim such and such by the MSCT District SEDI MP. The facts giving rise to the present appeal in a nutshell are that on 27 November 2013 at about 8:15 p.m., the deceased, namely Gokul Prasad, aged 32 years, was returning from home from a weekly market, traveling in a vehicle that is Tata bearing registration Tata 407 bearing registration number such and such, being driven by the respondent number 3 herein. Upon reaching near this road, the said vehicle, driven in a rash and negligent manner, met with an accident. As a result, the deceased sustained severe injuries and died on the spot. A claim petition was filed on behalf of the appellant's legal representative of the deceased under 166 of the MV Act 1988 before the tribunal, seeking compensation to the tune of rupees such and such, claiming the income of the deceased to be such and such per month, engaged as a cloth seller. The respondent insurance company opposed the claimant's appellant's claim and set up a plea of breach of the policy as the offending vehicle was being used as a loading vehicle without a valid permit, registration, and fitness certificate. This was in violation of the condition of the insurance policy. Also, the driver of the vehicle was also not holding valid driving license. Consequently, the insurance company is not liable to pay any compensation. The tribunal, vide order dated 19 December 2016, awarded compensation amounting to such and such, along with interest 6% per annum. The liability to pay compensation was fastened upon the driver and owner of the vehicle jointly and severally, as there was a clear violation of the terms and conditions of the policy. The tribunal held that though the vehicle was commercial in nature but driven by a driver possessing a license only to drive LMV, a non-commercial vehicle, furthermore, there was no endorsement stating that the driver was authorized to drive the commercial vehicle. Subsequently, the tribunal concluded that the offending vehicle was insured under the liability-only policy, which covers only third-party liability, as no premium was paid covering the driver or owner of the vehicle. Being aggrieved thereof, the owner of the offending vehicle preferred an appeal before the High Court. The High Court, vide impugn order dated 12 December 2022, dismissed the appeal filed by the owner, affirming the compensation awarded by the tribunal. The court observed that the insurance company stood rightly exonerated by the tribunal, with liability being fastened on the driver and owner of the vehicle. The High Court gave the following findings by referring to the decision rendered by this court. By relying on such and such lawsuit, the High Court held that the endorsement or any other authorization to drive a commercial vehicle was not required if the driver was holding the license to drive light motor vehicle. The offending vehicle is insured under liability-only policy, which only fixes the liability of the insurance company towards third-party liability. Since no premium was paid to cover the liability of the driver as well as any passenger traveling, in the light of the law laid down by such and such, the court came at a conclusion that liability of the insurance company stood rightly exonerated. The present appeal has been instituted by the claimant appellants. The significant ground for challenging made is that in view of law laid down in National Insurance Company versus such and such, wherein the court observed that in case of gratuitous passenger, the insurance company was liable to initially pay the compensation amount to the claimant appellants and then recover the same from the insured. The court below ought to have adopted the principle of pay and recover. We have heard learned counsel for the parties. We have also heard the learned amicus curiae, Ms. such and such, peruse the calculation chart prepared by her, indicating such payment of compensation to the claimant appellants, which is just and fair. The findings of the courts below reveal that the driver of the vehicle involved in the accident was holding a valid driving license to drive LMV. However, in fact, the vehicle in question is commercial one. We agree with the view taken by the High Court, holding that no endorsement was required to drive a commercial vehicle of the type in question by the driver who possesses a license to drive LMV. In the present case, the offending vehicle was Tata's 407 truck, having a gross total weight of around such and such kg, which does not exceed 7,500 kg. We must advert to the recent findings of this court laid down by the constitutional bench in such and such, wherein view taken by the three-judge bench in Mukund Devagwan Supra was affirmed, while observing that I may skip or
You may skip, Mr. I've read it. Only thing now which is bothering the court is the conclusion part. The court has not said anything regarding what do you call
pay and recover.
Yeah, pay and recover part. It has only cited few judgments.
Lordship may take lordship to paragraph 11. It's relevant from the paragraph 11. And 13 is...
No, I've read it. 13 I've read, 14 I've read, 15 I've read. Now, 20 is regarding recalculation. Now, the last part, paragraph 23. How it is to be paid and recovered, that has not been...
Paragraph 15, it was... paragraph 15. May I read, Lordship?
No, how it is to be executed, pay and recover. That is...
Usually, since I'm also from the insurance company, I used to deal with these such cases. The insurance company paid first, then we have filed the execution before the tribunal court to recover the same. That is the pay and recover, Lordship. The awarded amount will be paid first by the insurance company, and we have tried to recover from the.
Correct, I've understood that, but how do you recover that? The opposite party, they have also contested. The owner, driver, they have contested by filing WS. Correct?
Lordship, yes.
Are they related to you?
I'm not aware of that, Lordship,
Uh,
whether we are related.
all of you are traveling in one vehicle.
One vehicle.
5 of you.
Yes, total
Driver escaped. The owner of the vehicle expired.
expired.
Behind were sitting the other 3 passengers. They also expired. Supposing the deceased persons were your relatives. Insurance company pays you, you take the money. But tomorrow insurance company will catch your relative. Pay.
They will get back now.
So that's why I'm asking you. Now, paragraph 13, 14, 15 is the same thing.
Lordship, yes.
There are 3 different cases mentioned here. Pay and recover like that.
Lordship.
Now, is there any such criteria for pay and recover? Any particular, only in such kind of situation, court can direct pay and recover? Or that in all cases, pay and recover can be applied?
Lordship, as per my understanding, in gratuitous passengers, the Supreme Court had directed in another cases also, like a principle of pay and recover was adopted. The insurance company was directed to pay first and recover from the, because this is a welfare legislation, and the intention of the legislature is also that the victims should not suffer due to the accident.
Oh, I understand that. What I'm asking you is there any parameters set that it is only in such kind of situation that pay and recover can be done? Or it is that if the person is a gratuitous passenger, if the insurance is valid, although extra premium is not paid, the insurance should be directed to pay the premium, to pay the compensation and recover from the order. Which one?
Lordship, the last one, which
So that means generally.
generally, Lordship, yes.
There must be something like in your case, perhaps there was a insurance policy.
Yes.
Although premium for that passenger was not given, but there was an insurance
Insurance was
policy.
valid,
It was validly insured. Only that extra premium is not given. So what will happen in case there was no insurance?
If no insurance, then liability of the owner of the accident vehicle.
Okay.
Lordship.
If there's no insurance at all, then the insurance company cannot be said that you pay first.
Yes,
to
yes.
recover.
Yes. Because they are not liable at all.
Any other judgment?
Lordship, yes, one more judgment. This is 2001 SCC 273. 2001 SCC 273. Operative is paragraph 11.
This regarding
This is regarding pay and recover, Lordship.
pay and recover.
Pay and recover.
Any reference has been made to the earlier judgment you have cited?
No, Lordship. This is the old one.
Sunita, Baljit Kaur, Tokyo
it's-
General, not referred.
Not referred, Lordship.
11
Paragraph
portion,
11, Lordship.
11.
11. Page 241.
Okay. 241, yes.
Lordship. The result is that under the new act, this is a 1988 Act, Lordship, An insurance policy covering the third-party risk is not required to exclude gratuitous passengers in a vehicle, no matter that the vehicle is of any type or class. Hence, the decision rendered under the old Act vis-a-vis gratuitous passengers are of no avail while considering the liability of the insurance company in respect of the accident which occurred or will occur after the new Act came into force.
What is the new act thing?
New Act is 1988. 1988. Now we are using the new Act. The old Act is 1939 Act, MV Act. Here it says that in the old Act, the third party risk is not required to exclude the gratuitous passengers, because in the old Act also, the gratuitous passengers was paid first.
They were paid.
Yes, Lordship.
In the new act, they're not paid.
In the new Act also, it should not be excluded. It says that. In the new Act also, it should continue, as per my understanding, Lordship. Lordship. my submission, my conclusion is that presuming that if this is where the gratuitous passengers, but in any manner, the insurance company is liable to pay the compensation, the awarded amount to the claimants, and they may be free to get back that money from the owner of the vehicle, Lordship, since the policy is valid and there's this.
So there are execution cases pending before the tribunal
Lordship,
in
yes.
that,
In another case.
in other cases
Yes,
like
yes.
that. Insurance has paid
Yes,
and
Lordship.
then they have filed execution
Lordship, yes.
for refund of the amount from the owner.
Yes, Lordship.
And what is done by the tribunal?
Tribunal had called them before the tribunal, and in most of the cases, I'm also from the insurance company, Lordship. We are not able to recover that much of money. But however, we are a government-run the insurance company. We still have a lot of profit. So we are not much bothering about that. And in another case, just
So
frankly
you
speaking,
admit that the recovery is not very successful.
in some cases it is successful, Lordship, but in some cases it's very difficult to recover.
So that is your case then.
Yes, Lordship, that is my case.
Any reply from your side?
Lordship, frankly speaking, I have not gone to that citation. I don't know, but the accident in this regard is, the accident took place a bit late, since there has been some amendment. The accident in connection with the instant case took place in the year 2018. So there has been amendment in the year 2018 and thereafter in the year 2019.
Amendment of?
2019 also.
Amendment of what? Of the MV Act?
Yes, MV Act.
No. What has it got to do with the, I think the amendment which Mr. Johnny speaks about is 1988. The old act was the 1939 Act.
No, 1988 Act. In 1988 Act, there is an amendment on 22/5/2018, and thereafter on 9/8/2019.
So how what difference does it make?
I don't know, but but if I may be given some more times, I have to produce, and I think I may need to study again. Because there are lots of cases in like this. Even I myself has a claim petition like this case. It is still pending before the tribunal.
See, picture is very clear.
Yes.
Vehicle met an accident and the insurance policy was there.
Yes.
But the policy is only meant for the driver, owner, and for third party.
Yes.
So the relative of the deceased persons make their claim and the tribunal has awarded. Yes, you pay. Tribunal found the policy to be correct.
Yes.
Not that extra payment,
Yes,
premium, that thing was not discussed. Policy is correct. 1,900 rupees, 1,900 has been paid. Then other things are also okay. So tribunal ultimately says that since there was an accident and since it was insured validly, you are to pay. But now you come up with the contention, or you had made that contention also before the tribunal.
Yes.
That, see, we are not liable to pay because they have not paid the extra premium. Why should we pay? So Supreme Court also says that correct. Without extra premium, you may not be liable. But still, the principle of pay and recover is there. So this being a welfare legislation, and perhaps since there is a valid policy, not a complete policy, but a valid policy, you pay first and recover. So that is the sum and substance.
Yes.
And beyond that, what can we say? I mean, this court, we cannot say that you are liable. Although you don't pay the premium, you are still liable. Although they have not paid the premium, you are still liable. We have to accept your argument saying that you are not liable. But since there is a pay and recover thing, on that principle, you are still required to pay. End of the day, you will recover from them. Since you are comparing an individual to a company, profit-making company, individual cannot suffer. Profit-making company will give, but they will not suffer. They will recover. So recovering may take time. He has frankly said that recovery is very difficult, but recovery has to be there, this way or that way.
Yes. Even our company has also pending execution case. But
You know very well.
as far as my understanding, that pay and recovery used to apply when there is an insurance policy and the insurance policy cover all the liabilities. But in such a case, if the driving license are not valid.
No, it covers everything, then there is no question of pay and recover. You will say pay.
Yeah, even if it covers
If it covers everything, then you have to pay.
But if
there will be no recovery.
No, if there is a invalid driving license, the driver has to possess a valid driving license. In such a case, we used to apply pay and recovery.
Here, it is not your case that driver doesn't have license. Correct? I don't think that is your case. I think your only case is that extra premium is not paid, we are not liable.
Yes.
Had the driver expired, we could have paid him. Owner expired, we already paid him.
Yes.
But for those gratuitous passenger, we cannot pay because extra premium is not given. Why should we pay? This is strictly as per the policy, and in fact, this is what is provided by section 147, requirement of policies and limits of liability. So that discussion is there in this section. So if you want time to study that, you can have it till next Monday. We have it again on Monday.
Yes.
Since we have spent considerable time, just go through the judgment. Okay. Please write. Hard in part, list the matter again on 27/2026. 20 means 20, 20 July 2026, Monday. Court master, just come. See this judgment, no? You just take a printout. Take a printout, keep it in the file. Okay. Mr. Johnny also, you may look for some more additional citations.
Yes.
Which is more clear and which has, I mean, like which, I don't know, which may help you. This was item number
16, 17, and 18.
17.